mediation order.
That I beg to mention item 34, hearing.
34.
Maybe adjourn, my lord. For a week.
1 minute. Hey, doctor. এইখিনি লৈ যাও, এইখিনি লৈ যাও। কোন মানদে এইখন লগাই দিছিলে। Yes.
34. Maybe adjourn for a week.
For a week. Okay. You have the informed the other side?
Yes, my lord. I'm for the respondent.
Okay. On the prayer of Mr. S. Nath, learned counsel for the petitioner. The case is adjourned for a week. Mr.
D. Gugoi, my lord.
D. Gugoi.
Gugoi.
Learned counsel for the respondent number 2, 3, and 4. Is present and has consented to the said prayers.
Obliged.
I beg to mention for orders on Friday.
Orders. Give it to the court master.
May I please, Your Lordship, in item number 19 of today's list, I filed an affidavit yesterday that may be called for.
Okay.
For orders, my lord.
May I raise your Lordship? Lordship, I pray for listing of a matter for admission. Lordship, Lordship,
Okay,
can
give
it be taken up tomorrow? The urgency is, Lordship, because it was pertaining to a departmental proceeding. Notice on interim was issued. Now I am being pressurized to submit my written statement within a week.
Okay, Monday.
Lordship, 1 week time has been given to submit. Any week, any day. Lordship, on 20th, the last hearing was called.
Friday.
Right. Obliged, Lordship.
May it please the Lordship. Lordship, I beg to mention for a listing of a writ petition. It's a motion matter, Lordship. Can it be on Friday, Lordship?
I'd like to mention item 36, my lord, with the consent of the other side, my lord. Can it be fixed after vacations, my lord?
Okay. Mr. A.K. Sahewala, learned counsel for the respondent number 1 to 6. Next week.
After vacations, my lord.
After vacation. Okay. Has made a prayer for adjournment. It is submitted by him that the case be listed immediately after the ensuing long vacation. Those it is further submitted that he has taken consent of the learned counsel for the petitioner to make the prayer. The prayer is allowed, list the case immediately after the ensuing long vacation on date 2 weeks by the office.
Grateful.
For admission.
May it please your Lordship. Lordship, I beg to mention an item for listing. Lordship, it is an old matter. The matter had last come on the 18th of December,
Okay.
2024. Lordship. Much
May I
obliged.
please? I beg to mention item 41 and 42, my lord, with the consent of the other side, my lord.
40
This matter
and
I'm led by senior advocate K.N. Chaudhary, my lord. So he has requested me for accommodation on the 14th of October, my lord.
okay.
I'm for the respondent ONGC in both the matters.
Okay.
40 and 41.
40 and 41.
Mr. B. Prakash, then counsel for the petition has read for listing of the case immediately after the ensuing long vacation. Mr. S. Sokrovri, learned counsel for the respondent number 10. Or your
ONGC, I'm for ONGC.
respondent
ONGC.
agency authorities.
Both the matters.
Has submitted that he has no objection to the state prayer, as agreed to and as sought for and as agreed to by the learned counsel for the parties, list the cases on so and so.
24th October, 2410.
May it please the Lordship, I'm praying for listing of 3 motion matters on Thursday, Your Lordship.
Thursday, most of
Lordship, the reason being is that a similar matter is listed on 4th, Your Lordship. So these matters can also be covered by the same. On 4th.
May I please, Your Lordship? Lordship, I beg to mention item number 18, Lordship.
Yes,
18, Lordship, with the consent of other side, Lordship, kindly, Monday, Lordship.
you are for the petitioner.
No, Lordship, I am for the respondent, Lordship, standing counsel, Animal and Husbandry Department, Lordship.
Mr.
DJ Boro, Lordship, on behalf of J.K. Goswami.
Okay, thank you. Standing counsel, Animal Husbandry and Veterinary Department. List the case on so and so. Consent petitioner.
May I please, Lordship. Lordship, praying for listing 2 similar matter, my lord, in admission column, my lord.
Give it to the court master.
May it please your Lordship. Your Lordship, I beg to mention for listing of an interlocutory application, civil interlocutory.
Give it to the court master.
Obliged.
Supplementary list for motion, item 39.
May I please, Your Lordship? Lordship, in compliance of the MCC Lordship, the State Election Commission, they have issued a letter that Lordship will find at page 52. This was intimated to the Principal Secretary of BTC.
52.
52, Lordship. I'm coming to that, Lordship, MCC, but this one, in compliance of this, Election
Restriction on
Commission has
transfer of
issued
personal-
this
yes,
order.
So it refers to, so I'm directly informing. This part contract of is currently underway. As of the right? Other multiple functional sales have. selected for also. Yes?
Yes. Now, Lordship, the impugn order issued annexure C, page 53. My name is at the first one, in the international so-and-so, is transferred and posted so-and-so, and in my place, the respondent number 5 is brought in, Lordship. This order issued on 20th August, Lordship, this date is crucial, Lordship. 20th August 2025. In so-and-so is transferred and posted as executive engineer so-and-so. Transferred with, this is important, Lordship, with effect from the date of taking over charge. First one is me, second one is in my place, that is the respondent number 5. Now, immediately thereafter, this was issued on 20th August. On 22nd August 2025, the respondent number 5 is entrusted with the election duty. That Lordship will find at page as a zonal officer. Lordship, relevant portion is at page 58 for Runikata zone. Immediately after 1 day and before assuming charge. 22nd, impugn order on 20th August. This election responsibility is given to respondent number 5, who is brought in my place as a zonal officer. Starts from page 55 and the charge is at page 58.
Since when you are in there?
Yes, Lordship.
Since when you are in?
2017, 5, 2023. Not more than two years, Lordship. Not completed 3 years. Now, Lordship, immediately, Lordship, on 26th, the date of election is issued. That Lordship will find at annexure E, page 60. When the election will be held, what are all this schedule is given. Now, I received this Lordship order on 26th. So immediately I file a representation before the concerned authority. That Lordship will find at annexure F, page 63.
So election notification is on 26th August.
26 August.
And how and when the model code of conduct
Yes,
comes into force?
Lordship, with effect from 26, that Lordship will find at page 61, issue of notice of election. The schedule of general election is given, page 61, issue of notice of election.
So when model of code of conduct comes into
With effect
force?
from 26th of August.
So this notification or this letter,
On
this-
2nd of August, restriction is imposed. For the person concerned who is having the election responsibility, they cannot be transferred.
directed to.
But in administrative action, they can do so, but with the prior approval from the State Election Commission.
Were you assigned any election related?
I am not assigned, Lordship, but in my place, the respondent number 5, who is given the election duty, he is brought in. Now, Lordship, please kindly see the bar. Now, admitted fact is that from 20th August, from the date of issuance of the transfer order till the date of notification of the election, no one is assumed charge. The transfer order itself says it affect from the date of assumed charge. Now the bar, Lordship, will kindly come, page number 33. It's a gross lordship violation. This is the model code of conduct, and the from page 32 on transfer and posting officials, these are the guidelines. And this is lordship grossly violated, lordship 6, this is 7.6. May I read it, lordship? The transfer orders issued, page 33, 7.6. The transfer orders issued in respect of the above categories of officers, that is zonal officers, that is 5. Prior to the date of announcement, yes. Here, lordship, the transfer order is issued prior to 26th of August, that is on 20th August of announcement, but not implemented till the time when model code of code came into effect. Now, model code of conduct came into effect with from 26th August. My specific case is from 20th of August till 29th of August, no one is assumed charge. So therefore, how it can be affect, this can be affect should not be given
Transfer
to
order issue.
without obtaining specific permission from the
Let us
regulator.
see the total. Before that, you read 6. Let us see 1 to 5 also. Commission narrated that there is a total ban of transfer of all of.
Until 29th, lordship, he taken unilateral charge on 30th August after issuance of the letter from the authority on 29th August. If your lordship
Now,
permit me,
the Roman 6,
Roman 6, lordship,
Roman 6
Roman 6.
mentions about above categories of officers.
Yes,
Now, which one you will fall?
his lordship, this section officer, page 33. The response number 5, he falls under, sorry, lordship. Or other officer drafted for election works like
Yes,
sector and zonal officer. It is zonal officers. The response number 5 is the zonal officers. So my submission is that
This is a police, other officers drafted.
it's a specific bar, lordship,
Covered by this right.
above categories of office.
Issued in respect of a prior to the date of the time.
লিখুন। Even the transfer order is also not communicated to the authority, lodge. Specifically mentioned from the date of assume of charge, date of taking over charge. It will come into effect from the date of taking over charge.
What do you mean by not implemented?
The effect of that is logic here, kindly say I have that's handed over the letter on 29th. On 29th, the authority
29th?
requested the, just now I have handed over the letter, logic. So admitted fact is that till from with effect from 20th to 29th, the order is not implemented. That is, they have not, meaning they have not taken over charge or assumed charge. Now this
Yes.
clause 6, this clause 6 specifically to give effect, prior approval from the state election is mandatory, Lordship. So that is my case.
The transfer order is of 20th August, Lordship. And regarding the model code of conduct, election notification of BTC, it came out on 26th August, Lordship.
Yes.
Yes.
That means from 26th August, model code of
That is
conduct
at
will
page
be-
60.
will be applicable, Lordship. This is the
Yes.
model code. Page 60, Lordship. Lordship. Moreover, Lordship, regarding the transfer of respondent number 6 as zonal officer, Lordship, some other officers has already been appointed by the election commission, and this is his appointment order, Lordship. In place of respondent number 5, other officers has already been appointed, Lord.
I am concerned with respondent 5.
Is just separate from the documents annexed.
Yes, Lordship. Model code of conduct.
Which one is correct?
Lordship, regarding the announcement of notification is 26th of August, Lordship.
Yes, notification.
So
Hmm.
on the, from that day, model code of conduct will be applicable, Lordship. And transfer order was issued on 28th August, Lordship. And
Now you say this one is of what date? 22nd.
26. What's your CD file number? SEC 41.
This one is 27.
model code of conduct.
So on 27, this has been changed again. Suboldas is no longer.
Yes, Lordship.
But the date of election is same, 26. Model code of conduct
Now
is same.
one Mr. Deepak Wari or
Yes.
Khata, Kungring. So as on date, neither of you,
No,
neither of you.
on 30th, Lordship, he assumed charge. The respondent number 5
No, no,
assumed charge.
I'm asking you a query. You were not given any election duty.
No, Lordship.
That man, the other man, the charge is also changed. Some other person has been given.
That I am not able to.
This is a document he has
Yes.
said. So neither of you
Let me.
are related with election
Because
duties
my
or
allegation is
nodal officer,
specifically-
sector officer,
Lordship,
whatever.
my case is specifically against this Subal Chandra Das.
Right, Subal Chandra Das is no longer given any duty.
That-
That has been changed. Initially, that
Subsequent
Annexer
development-
D. Annexer D, again in partial modification, another order has come. Now one Mr. Deepak Wari, he is the zonal officer and sector officer for
I'm
Tuni
not
Khan
doing-
all.
But the Lordship kindly see on 29th, then Lordship kindly see this 29th letter. He was directed to take over charge. How is it possible, Lordship, then?
No, question is first question is Roman 6. Come to
Roman 6.
Come to Roman 6.
Yes, yes. The transfer orders.
Come to Roman 6, not transfer order. Model code of conduct.
Yes, it starts from the transfer orders.
Ah.
Transfer orders
You said
issued.
zonal officer, right?
Zonal officer,
Roman 5.
Roman 5.
Other officers drafted for election works like sector or zonal officers.
Yes.
Right? Roman 6. The transfer orders issued in respect of the above categories of officers prior to the date of announcement.
Lordship,
That is 2nd August. 2nd August,
Lordship.
right? But you are not zonal officer
No,
at that point of time.
yes.
Neither was he. At that point of time, 2nd August.
Second, level.
2nd August. The transfer order was on 2nd August.
No, 20th August.
Okay. That other order was on 2nd.
Yes.
August. Okay.
That is a general order, but
Okay.
order is
Transfer
20.
orders issued in respect of above categories of officers.
Yes, on
Right?
20th August,
You were not.
Lordship.
He was subsequently. Subsequently means on the 20th August.
20th August.
20th or
22nd.
22nd, subsequently.
Immediately after.
At
work day.
that point of time, he was also not zonal officer.
Yes,
On 22nd, he was made zonal officer
Lordship.
pursuant to the transfer order.
Yes.
27, he was not made a zonal officer.
With effect from 22nd.
27, he was made zonal officer.
Yes.
On 27, partially modified, he has been changed.
But Lordship, if it is my, now, just now I came to know, if it is changed, this is the letter of 29th of August, whereby it says, Lordship, kindly peruse this old letter. In the interest of public service and administrative efficiency, Shri Subal Chandra Das, Executive Engineer Sirang WR Division, who was transferred and posted as Executive Engineer Borpeta Water Division, Height Notification 20th August, is hereby directed to take agent charge.
Now,
So
both
meaning
of
thereby-
you are not zonal officer.
Now, in my place, the response number 5,
Now, let us again see this notification. You said
20. The transfer order, Lordship.
transfer order is 20 August.
That, yes, notification of election code of conduct. Yes, yes,
Transfer order.
yes. Date
I
of
think 20.
53. It specifically says transferred with effect from date of taking over charge.
Okay,
So
done.
once they take
Done.
over the charge,
At that point of time, you were not zonal officer. Neither was he,
both of us.
both of you, right? Then on 22nd, that man was made zonal officer.
True.
On 27th, he was removed from zonal officer.
That officer, I'm not aware, Lordship.
That is what they are giving
Just
it.
now I come to know, Lordship.
Huh.
But now,
So, in that case, we again read Roman 6, page 33.
yes,
The transfer order issued in respect of the above categories of officers, right?
Hmm.
That is 20
prior
August.
to the date of announcement,
20 August.
that is
20
20,
August.
20
Prior to
August.
the date of announcement,
That is 26.
but not implemented.
This order is not implemented.
Not implemented till the time
When
when
model
model code of conduct came into effect.
That is 26
Should
August.
not be given effect to
Yes.
without obtaining
So
specific.
this is my
permission.
case.
Right.
My
Right.
specific case is without taking the approval of the State Election Commission, this order, transfer order cannot be given effect to Lordship. That is my case. And that is what is barred in this model code of conduct. Even till today, that is Lordship, and admittedly till 29th, no one is taking assumed charge. The meaning thereby, it says that from the date of effect, date of taking of charge. So meaning Lordship, till the 26th of August, Lordship, no one is taking over charge. So already Lordship, it came into force. So it cannot be implemented now. So at this Lordship, my respectful submission is that Lordship, at least Lordship, now election will be over by 28th of September. So till that, at least Lordship, it will be firm protection to be given. 28th of September. Basic.
We are examining only that. After that, nothing remains.
Otherwise, Lordship, I having the authority, it says, Lordship, if the approval is not
This is
taken from the
22nd.
election commission, that order is null and
This
void.
22nd.
Recently of judgment of Lordship, Allahabad High Court, It's-
22nd. The 6th August,
so once the notification is issued,
22nd, 26th August.
that transfer order cannot be given.
1 minute.
Lordship.
This man Subal Chandra Das, right?
Lordship.
The respondent.
Aye.
He has also been exempted. He has been done away with.
But
Neither you nor he is
according to them,
related to any kind of election
sir,
duties.
according to them, Lordship, this letter issued on 27th of August.
Right.
Then, Lordship, what is the purpose of issuing this letter on 29th of August?
This is normal transfer.
No, it says, Lordship, reference is given on 20th August.
So otherwise you are not involved with any election duty, right from very beginning.
Yeah, but in my place,
Is it a
because
fact or not?
to accommodate the respondent number 5.
That is another issue, accommodation. You are bringing your case within model code of conduct,
Yes.
right? So far you are concerned, there was nothing like sector officer or whatever, zonal officer. No election duty, whatever, has been entrusted to you. But on 28th August or 22nd August, after the transfer order was issued on
Yes.
20 August, he was given some responsibility of zonal officer. Though it was not implemented according to you,
Yes.
but
No,
he
admitted
has
fact.
already been given responsibility. So far you are concerned, not. Right? And subsequently, on 26th August, it came into force.
Code of
Then it should have been his case. That how 27 August I should be exempted.
because both of vice versa, Lordship. Because
Vice versa, that is a different thing. You don't have any case.
in my place,
You are not entrusted with any kind of election duty. Basically, transfer is when the election is in the offing, people should not, an officer who is already accustomed to the area should
Yeah.
not be kept in that place so that he goes in a new area. Otherwise, it is 3 years.
3 years.
But
here it is not 3
election
years.
time, it may be different. So he may go to another place so that neutrality is maintained. But you are not given any election duty. Yes, had he come, yes, 22nd enforced. On 22nd, my order has come, and 26th, model conduct came. How can you issue an order on 27th exempting me from election duty? Maybe the deputy commissioner may have power.
No, it is only the state election commission with the approval. It's required. The authority says
That
what
is for him to hesitate,
it is the state
not
election
for him to
commission
hesitate.
during the
You
once.
cannot hesitate your challengers.
So once the notification is issued, Lordship, it is only the election commission, he is having the authority.
But that cannot
there
be
was a-
read into this.
and
This
this-
page
this-
33 clause 6.
This order, Lordship, 20th order, I received on 26th. And suddenly, Lordship, that after I filed this representation,
Mr. Deka,
Lordship.
so far page 33 clause 6 is not applicable to you. Because you do not fall in the category of officers. If my understanding is correct. Which if you don't fall, you cannot enforce this. Subject to correction.
But the person who is trying to vote in my place,
You are not standing in your shoes, in his shoes. You are standing with your shoes.
They're trying
On.
to replace me, Lordship, by
That is,
5%.
you
By
cannot
person-
enforce.
5%.
So far page 33 clause 6 is concerned, you cannot enforce. It is the other one
22nd.
who can enforce. If I have understood the meaning correctly, above categories. So as on that, you do not fall into that category. Right from the very beginning. One who do not fall, he cannot enforce this. It is the other one. If he does not want to, he is divested of the responsibility of zonal officer by a subsequent order. We are not into his case, we are into your case.
But the other good that
You cannot agitate the respondent's case.
immediately, Lordship, I file an application before the authority stating the reasons, Lordship.
That
But
is,
the-
yes, he may be hard, both may be hard, that is a different thing. Now he is divested of the
But my-
responsibility.
Both the daughter.
Both are not having any election duty, it is for them to consider the
Beside
representation.
this, the other ground is the Lordship, both of my daughters are the final examining. Lordship.
Those can be considered, that is a different thing.
At least
Both of,
I-
none of you now are,
So even in the.
none of you are responsible with election duty.
But even in the, I categorically stated the Lordship, till the date election is over, Lordship, some protection should be.
Oh,
given.
no, that's,
Till
we
the
do
29th
not do. we do not
29th,
do-
Lordship.
We
28th.
cannot read into all those. Your representation can be considered. That is a different issue, but so far your enforceability of the model code of conduct, we don't find anything. Or at least interim relief. Yes, other side.
Lordship, the concerned person.
They
has-
make it, they can make out a case for you. Let us see. Let us hear them patiently.
Lordship, the concerned person has already been released from BTC on 23rd of
Who
August.
concerned person?
Means respondent number 5.
Released
Yes.
from BTC.
Yes. And on 26th of August, he has submitted his joining letter, Lordship. And on 29th, he has assumed the charge also, Lordship. This is his charge assumed.
Unilateral. Unilateral,
Yes, that is on 30th August.
29. Submission of joining letter. Whose signature is this? On 26th August?
This is the signature of respondent number 5. That is the joining letter. He has already joined in Propeta. Respondent number 5, Lordship.
This is unilateral. Is it not?
Yes.
This is unilateral.
Lordship, as because petitioner has not handed over the charge to respondent number 5, Lordship.
This is unilateral.
This is an NOC from BTC, which
NOC is already there.
Lordship, according to the Lordship, both of us are not with the election duty. The admitted fact is that on 30th of August, Lordship, he taken the unilateral charge. There is a letter of 29. I filed the representation on 26. Let him have a decision, Lordship. Considering my other grievances, Lordship, because both of my
So
daughter is the final examinee.
Yes, Mr. Deka,
Lordship.
what is the condition precedent for submission of a representation to review the transfer order? What is the settled law? You tell me about the settled law.
Unless it is modified, your Lordship.
Huh? Tell me of the settled law. What is the condition precedent for submission of a representation?
Have to join, Lordship.
That is the settled law. And we cannot now, had it been other times, in other normal situation, I had said that
Now, in
this-
view of this letter of
in
27th
view of
of
the election, the issue.
the 27th of August. Now, both of us are not
Yes,
having
let's
any
do
election
a-
duty.
Nayak, you are for whom?
Right now, Lordship, post at Sirang under my authority is lying vacant, Lordship.
The place where he has
Yes.
been transferred.
He has been transferred. So let him join the new transferred post, Lordship. Let him submit a representation. Authority will
What
consider.
are your difficulties, Mr. Deka?
My difficulty, Lordship, is both of my daughter is the final examiner, Lordship. Higher secondary and HLC, Lordship. They are studying at Borpeta, Lordship.
Consider for level.
So suddenly I received this letter on 26th of August.
Representation can be.
So immediately on 26th, Lordship, I filed this application. Even, Lordship, in my Lordship, I categorically stated that till the election is over, Lordship, thereafter, Lordship, I may move, Lordship.
No, election, I mean,
No,
their
it-
examination will not be over.
my
till
record
time.
will submit
Come
that
to page 63.
Lordship,
Come to page 63. That is your representation?
63. Lordship.
You don't have to worry about organization of official and site related works. It is like roster. I am here for this week.
And
My
if Lordship comes to the
brother
la-
judge will come. He will take over from the stage where I have left over. And this is only official.
and if Lordship comes to the last line
Don't
of
to
that,
worry about official works. He will take over.
that we will take care of, Lordship.
No,
Lordship,
children
kindly see the-
education is
Lordship,
there.
Kindly see the intention of the petitioner, Lordship. He is not in the view that he will not move, at least in the completion period, considering the daughter's.
Mr. Deka, what you have submitted orally, that you are having these difficulties, that is not in the representation.
That is not in it. Yes.
And last
Because-
line is Lordship. in
That
the-
is humanitarian one, but this is official one. Official one, every
Correct.
office
The true, Lordship.
has a successor.
Lordship, hurriedly,
If I
Lordship,
do not sit tomorrow, my brother judge will take over from the stage where I have left over.
Lordship, on 26
So
immediately.
there is nothing that somebody is indispensable officially.
But
Heard, Mr. Edeka.
the intention of the petitioner is good, Lordship. He
Good.
received this
I'm
letter
not
on
saying that
26.
bad.
So immediately, Lordship, on an official, because he written this letter. In paragraph
It
15,
is
Lordship,
good.
I have
I am not
stated-
saying that
Yeah.
am I imputing something? No, absolutely not.
In paragraph 15, Lordship, I have, Lordship, that is Lordship. Even he is ready to move, Lordship, after the election, Lordship. That is what indicated in
It is
the.
not your representation. This is lawyers drafting of writ petition.
It's contradictory, Lordship. Even if we allow him to stay till the completion of the elections, his daughter examination will not be over.
No, I am saying that he there the final
Edeka.
examination.
When it comes
Final
for the
examiner.
petitioner. Mr. RM Deka, RM Das, you are for
What, response number 2 and 3?
2 and 3.
One.
One?
Secretary. Chief Secretary.
Chief Secretary. I think he is Water Resources Department.
No. Special Chief Secretary is Water Resource Department. Chief Secretary will be represented by the.
Oh, Mr. CKS Borua or Mr. MP Nayak, Lanet, Additional Advocate General, and Roman and Standing Counsel. BTC for the respondent number 1 and Board and Mr. R. M. Das, understanding of Water Resources Department for the respond number 2 and 3. Post of the petitioner. He is a member, he is presently serving as an executive engineer in the Water Resources Department. Common Government of Assam, post of Para. By an order. By a notification dated 20/08/2021, Annex C. The petitioner who has been serving as executive engineer from a Borpeta WR division, has been transferred and posted as executive engineer Sirang WR division. With effect from the date of taking over charge, posted by the same notification, the respondent number 7, who has been working as executive engineer, Shirang WR division, has been transferred and posted as executive engineer, Borpeta WR division. With effect from the date of taking over charge, posted. There are Mr. Becca, the council court of petition, has submitted that subsequently and prior to a notification dated 20/08/2025, the Assam State Election Commission, ASEC, wrote to the Principal Secretary, Boroland Territorial Council Board, PTC, on 2/8/2025, requesting the PTC authorities not to undertake any transfer process of any personnel who has been assigned with election duties for the purpose of maintaining continuity. Post up. Subsequent to the notification dated 20/08/2025, the ASEC has issued a notification on 26 August 2025, declaring election to the General Council of PTC. And with the publication of the notification on 26/8/2025, the model code of conduct came into force. It is the contention of the council for the petitioner that as per the model code of conduct, any transfer order issued in respect of the defined categories of officers prior to the date of announcement, but not implemented till the time when the model code of conduct came into effect, should not be given effect to without obtaining specific permission from the ASEC. He has further contended that The response number 6. On 20/08/2025 itself had been assigned the duties of zonal officer by the district election officer, Sirang district, when the order of transfer dated 20/08/2025 was not even implemented. Post of. Mr. Das, standing also. Water Resources Department has submitted that. So. Oh, sorry. Was not 22nd was the assigned duties of so and so. Though the respondent number 6 was assigned to discharge the duties of zonal officer on 22nd August 2025. Subsequently, the district election officer, Chirang, has exempted the respondent number 6 from the duties of zonal officer by an order dated 27/8/2025. Post of Mr. Das has placed a copy of the order dated 27/8/2025, by which the respondent number 6 has been exempted from the duties of zonal officer. Post of. He has thus contended that neither the petitioner nor the respondent number 6, as on date, are entrusted with any election duties. And as such, the prohibition contained in the Model Code of Conduct would not be applicable to them. Where in reply, Mr. Deka has submitted that by an office order dated 29th August 2025, a copy of which he has placed, the respondent number 1, respondent number 2 has directed the respondent number 6 to assume the charge of Borpeta, Executive Engineer, Borpeta WR Division, with immediate effect. Post of. The office order has mentioned that it has the approval of the competent authority. The matter is for consideration, issue notice, returnable expense. Steps. Yes, accepted. So and so. Extra comments. Had the interim pair for staying. The line counsel for the parties are heard on the interim prayer for stay or suspension of the notification of transfer dated 20/08/2025. Post of. From the Model Code of Conduct, it has emerged that the transfer orders which have already been issued in respect of the defined categories of officers prior to the date of announcement, but not implemented till the time when model code of conduct came into effect, should not be given effect to without obtaining specific permission from the ASEC. And the ban continues till the completion of the election process. Post op. The election process has already been announced on 26 August 2025. And accordingly, command of model code of conduct came into force on and from 26 August 2025. Post op. On the date, the model code of conduct came into force, the petitioner was not assigned with any election related works. Full stop. The respondent number 6 who has been transferred in place of the petitioner to Borpeta WR division was assigned election duties of as zonal officer by a subsequent order dated 22/8/2025. Full stop. However, later on, the respondent number 6 has been exempted from the election duties as section officer by another office order dated 27/8/2025. Full stop. In view of such fact situation, neither the petitioner nor the respondent number 6 as on date are assigned with any election duties to bring the model code of conduct, to bring in the applicability of model code of conduct for either of them. First of, in such view of the matter, this the prayer for taking leave for violation of the model code of conduct cannot be countenanced.
24/9.
Pendency of the writ petition, it is however observed, Mr. Deca has further submitted that the petitioner has already submitted a representation against the notification of transfer dated 20/08/2025 on 26/8/2025. Post stop. It is observed that pendency of the writ petition shall not be a bar for the respondent authorities to consider the representation with regard to the grievances, difficulties or grievances highlighted by the petitioner in the said representation.
Lordship has directed him to join the new post, Lordship.
I have declined. It is up to you, up to him.
No, Lordship directed for consideration of.
I have declined the interim prayer
Yes,
for stay or suspension of the
transfer.
transfer.
Yes, Lord.
Other things follow. If somebody doesn't want to join, it's up to him.
No, only, I am only with the precondition for consideration of representation, Lordship. We'll consider if he join the new post, Lord.
In accordance with
That one
in
line,
accordance with law.
Lordship,
Law is settled.
Lordship. Lordship. And this is respond number 6. It is not respond number 6, it's 5, Lords.
5, all 5, huh? So 5.
For referral to mediation, item number 1.
Yes, Mr. Hawk, what is your subject matter?
Family pension matter.
Family pension.
Yes, sir.
Yes, finance. What is others? Education. And others? Not prepared. Whoever is the standing counsel for the respondent authorities, after passing the order, you please inform the responsible officials after mediation the date of mediation, right? Will or pass the order. Mr. S. Hawk, Learned Counsel for the petition. Who is Education Department?
I am for.
You were there.
I am for elementary department, Lordship.
Elementary only.
Lordship.
Miss
S. Kaur.
S. Coral and its Standing Council, Education Elementary Department for the respondent number 1, 2, 3. Miss U. Sharma, its Standing Council, Junior Government Advocate Assam for the respondent number 4, and Mr. Finance, Mr. P. Nag, Standing Council, Finance Department for the respondent number 5 are present. Most of the subject matter of the writ petition is family pension as a? Okay. Son?
Daughter.
Okay. Family pension is a claim for family pension by the petitioner as an
Unmarried daughter.
unmarried dependent daughter. Okay. Para. There are 2, 3, 4. First date, 10th of December. 10th of December. 10th. Sorry, September. I'm sorry. Sorry. Okay, order likhibo. The Learned Council appearing for the official respondents shall apprise the responsible authorities in their respective departments about the first state of mediation.
Item number 2.
M. Soikia,
Lordship, Meta has become infrastructure.
infractions.
Yes.
The counsel for the petition has submitted that the subject matter of the petition has become infractious. This AGAR, Central Government Council. For the respondents. Is in attendance. In view of the above submission made by Mr. Soikia, counsel for the petitioner, that the subject matter has become infractious on the petition. This.
Item 3.
Yes.
Hello,
What is the subject matter?
The petitioner was denied provisional pension.
Provisional pension.
My lord, in the meantime, my colleague appearing for AD office, he has shown me the PPO order has been issued. And I have also taken instruction. Some ADR pension has been received by the petitioner, but the monthly pension is yet to be received. Lordship, we fix the matter after puja vacations. In the meantime, perhaps, my lord, the matter can be closed.
We put it on 10th, then they can also inform. Then instead of waiting for puja vacation, you can get it early. The mediator may persuade.
As your lordship pleases.
T. Chakraborty, petitioner. Mr. D. Bhattacharya.
Yes. Respondent 3.
Accountant General.
Yes.
Okay. Standing Council Accountant General. For the respondent number 3. U. Sharma.
Respond number 1, 4 and 5.
1, 2, 4 and 5. Provisional pension.
Yes, ma'am.
Subject matter. Second লিখে দিব এইটো আগৰ লাইনটো লিখি দিব that SIG and Sharma official respondents shall apprise the responsible authorities in their respective departments about the first date of mediation so that the responsible officials attend the mediation process.
Item 4.
10-9.
10th of
10th. Both online, offline, hybrid, everything.
My lord, this matter, my lord. Here, my lord, the respondents authority was sought to recovery, my lord, alleged excess salary, my lord.
Recovery?
Yes.
Excess salary?
Yes, my lord.
We put it on 10th. If not, then we'll immediately pass the order.
My lord, my lord.
Are you enjoying stay?
Yes, madam.
Good.
My lord,
As Hawk petitioner. Neog.
Yes, Your Honor. DS Neog.
DS. Standing Council Irrigation.
Irrigation.
1, 2,
3 and
Three.
5.
5.
Three and-
A guy, Miss
A Sharma on behalf of Mr. B Chakravarti, or 4, Lord.
4. Accountant General, Assam, 4. With regard to a recovery process
It's 32.
for drawing for allegedly drawing excess salary.
My lord.
Okay. Limit, you go. Or again, 10th.
My lord.
5.
BPO.
Kumani building. Yes, madam.
My lordship, my senior is out of station, my lord. Kindly give us another date.
Maybe a covered case, let us see. Before the, yes, madam, what, B Islam?
Yes.
You are for B
My
Islam?
name is J. Ahmed.
J. Ahmed. Land Council representing Mr. B Islam, Land Council for the petitioner, PWD, Miss
Ande on behalf of Ardhar.
Ardhar.
Respondent 1, 2, 3, 4.
PWD, 1, 2, 3,
Four.
4. Miss, so B for B, yeah? The Accountant General, Assam for 5, Mr. C.K.S. Godwa, and Junior Government Advocate, Assam for respondent number 6. Regularization of his service. Aim for regulation of service on the ground that the petitioner had completed more than 20 years of service, and as such, the case is covered by Songita Roy and others versus State of Assam and others reported in 2019 to TLT A05. Limit of settlement by in Sobekali. 10th of September.
Item number 6.
Yes, Mr. Ahmed.
May I please, your lordship? This regarding non-payment of.
Just by being entitled, have denied the benefit, compassionate family event.
Yes.
Compassionate.
Yes, Lordship, this has already been initiated, Lordship, and we have instruction that there are some, once it was submitted, Lordship, but there was some observation by the Accountant General, Lordship. So it has been returned back. So
Try to sort out mediation.
yes, Lordship.
M. Ahmed, petitioners. M. Bhattacharya. Additional senior government advocate for respondent number 1.
1, 2, 3, and 6.
1, 2, 3, and 6. D. Bhattacharya, D. Bhattacharya. Standing Council Accountant General Assam for respondent number 5. Finance, H. Walia. H. Walia, Standing Council, Finance, respondent number 4. Compassionate family pension and other benefits.
Yes.
After premature date of the
Husband of
petitioner's
the petitioner
number
number 1.
one's husband.
Yes, sir.
Again, it's 10th of September.
Item 7.
Deeply.
Yes, Mr. Borbunya.
May I please, your lordship, my lord, matter relating to family pension lordship.
Family pension.
Sole surviving wife.
NH Borbunya.
Lordship, the law point is involved, my lord, mediation.
One line.
I say because the petitioner name is not in record of the office, service record of the husband,
Find out.
my lord.
MD Bora, transport.
Lordship,
1, 2, 4. R. A. Taluja.
For 3 minor.
Planning Council, Accountant General. Family pension.
Family
Family pension. As a capacity of what? Wife,
wife.
Wife lordship, sole surviving wife lordship.
family pension. As the petition has a second wife code, but it still is claiming family pension as the wife of the deceased.
Lordship, husband date, my lord.
10th
Then 9.
Mediation 10th. You inform the
Lordship, can it be on 9th?
9th. 9th. Yes.
Lordship, in the writ petition, the petitioner lady is claiming pension from the department. However, petitioner
Attaining
receiving
the
only
age of superannuation.
provisional pension.
No,
Pension.
yes, Lordship may
They have
kindly.
settled.
No, only thing is that Lordship may kindly, the updated thing is that due to non-availability of copies of appointment letter, joining some of the documents in her personal file and no proper entry in service book regarding her joining government service against regular vacant post. In this connection, Ajanta Gupta superintendent was requested to furnish the relevant office to this office by so and so letter. The status of the pensionary benefit have also been communicated to GAD by this office letter number of 2024. Further, as per instruction received from the GAD, in compliance with the order of Honorable Court, this office has initiated the process of release of provisional pension and other benefits to Srimati Ajanta Gupta on the basis of available records. So, Lordship, on that instructions, I was required to update the what has happened, Lordship, that from this court on the last date that where it has been directed to provide specific instruction as to apprise the court.
This, Mr. Barua, the intention is that the responsible officer should come, at least they should have a.
Lordship,
that
I have already.
Because sitting in offices, they don't realize. Let them come, have an interaction, thereafter things can be sorted out.
Lordship, before the mayor get one last opportunity to give a reminder or something like that, Lord.
Let us.
Because it's a letter of.
Mediation, let them come.
I think
should
in the mediation, in the mediation, the party.
They should be also
Yes, yes.
part of the process.
Yes, yes, absolutely, absolutely.
So that they can realize.
Yes, yes. Let the matter go to him.
Sitting in offices,
Yes, absolutely. Lordship.
moving files at their own pace, they don't realize that person without family pension or whatever,
Absolutely.
widow or some, how the fate goes. Mr.
IL Ngamla, on behalf of B. Barua.
B. Barua, petitioner. Oh. TKS Barua.
14789.
14789. GAD. A Fukan. A Fukan standing out of GAD. 2 and 3.
And for December 5.
Mr. C. Boro.
Arboro.
Arboro. Standing council representing Mr. C. Boro. Standing council accountant general. Assam for the respondent number 5. Mr. A. Soriha. Standing council finance department for the number 6. Family pension. Family pension?
Yes.
Family pension. 10th of September.
Awesome.
Item 9.
Yes, Mr. Hawk.
Yes, millet pension has already been released, millet.
You have got it?
Right.
Ms. Devi? Mr. S. Hawk, council for the petition has submitted that during the pendency of the petition, the petitioner's grievances have been redressed. And the petitioner has been issued pension payment order. Ms. L. Devi, council, standalone or council?
So I'm appearing on behalf of
Mr.
RKD Chaudhary.
Awesome. Representing Mr. R.K. Devchuri, here for all the respondent number 1, 2. Is in attendance and has you of the above permission, but Mr. Hawk, council for the petition is going to relief. The petition is closed.
Item 10.
Where is APDCL? Mr. CKS Barua, can you call any standing council of APDCL?
I'll inform you.
Pension of APDCL. Yes, normal list, na? থাকক এপিডিচিএল আহিলে কৰি দিম চাই লওঁ পিন্ধব কোনো নাই নেকি পিটিশ্যনৰ নাই নেকি পিটিশ্যনৰ নাই নেকি নাই
Items 11 and 12.
Lordship, here the date occurred in the year 2010. Died in harness. And
what is the
Lordship,
subject matter
compassionate appointment.
very complex
and once again submitted in 2015 submitted. So Lordship, as per the new executive order, it falls under point number 1, Lordship.
1 minute but executive order
Executive order of Lordship 30 August 2025, the latest thing. Lordship, perhaps yesterday I have. we have
petitioner is
submitted.
appointed as junior assistant
Could not be recommended by the DLC due to lack of vacancy. So they have challenged the DLC here.
while working as junior harness an application. This is for appointments. Complete submit. Okay. Each of those has submitted an application as patient. After DLC recommended.
TLC recommended, madam.
No.
And respondent
Only
number
see page
4
number.
forwarded the application related as a action to that. There is anything positive outcome despite me.
Case number 15. Case number 15, madam.
Page number 15.
15.
15.
Yes, madam. Last para, madam.
What is the name of this petition?
It is the minutes of the TLC, madam.
Four number.
Last para number 10, madam.
Ah.
4 numbers of applications are pending in the deputy commissioner amalgam estimate the vacancy post is, that is the vacancy post. Then my lord kindly come to page number 15, my lord. Page number
You have
15 is
read
there.
which part? Page
Page number
14.
15, para 10, my lord. Last,
Oh, earlier to that, which you have read?
yes, my lord.
Which para you have read earlier to that?
Earlier to that, my lord.
Paragraph 10.
Paragraph 10, my lord. Page
Ah.
15, my lord.
Okay, Bhanuprabha Datta, marks
Yes.
code 155.
Yes, my lord. Then kindly come to my lord, page number 21, my lord. Next DLC meeting, my lord, that is in 9/11/2015, page number 21, my lord. Relevant portion is in page number 22, para 3, last para, my lord. Bhanuprabha Datta, late Soender, has submitted one application for appointment on compensatory motive. Bhanuprabha Datta previously submitted an application on 18/6/2010 and was placed in the DLC meeting held on 7/12/2012. The district level committee was recommended her name by this office letter dated so and so dated 18/1/2020, and the minutes was sent to the state level committee. The state level committee did not approve the name of the Bhanuprabha due to non-mention of the vacant post against her name. At that time, there was a no vacant post of the grade 3 in this office. Now, one post of grade 4 is lying vacant. The district level committee was again recommended her name for appointment on the compensation ground as per petition, my lord.
The committee also is, committee also recommended.
My lord, page number 32, my lord.
What is this again? Page
Page 32,
12.
earlier
No,
state level.
Page 24 is what?
Page 24 is, my lord. District level committee, second time, my lord, in 2000, that was.
So second time,
9/11/2015. Her name was recommended, my lord.
second time.
Yes, my lord. First time also recommended, but due to, my lord, that is all.
Then thereafter,
Hereafter, my lord, kindly see in the first,
page 26.
case. Yes, page 25, my lord.
Page 25
Yes, my lord.
are recommended.
Yes, my lord. First time her name was recommended, my lord, but state level committee did not, my lord, that is, first state level committee is page number 32, my lord. Dated 2012-2014, and her name is in page number 33. Page number 33, paragraph. Paragraph 7,
Okay.
number 17, Udalguri district. my
Okay.
lord.
Then,
My lord, again, that is page number 21, my lord. Second district level committee is on 9/11/2015, my lord. Then, and,
this is district level, page
district level.
21.
Again, second time district level committee.
How many time district level?
First time, my lord, state level committee did not consider due to that is in, stated in paragraph 33.
First is
Page
page
number
14.
Yes, my lord.
First is page 14.
Yes, my lord.
Then it was placed before the state level committee.
Yes, my lord. That is. page
Then that
33.
is at page
33, my lord.
33.
Yes, my lord.
You have to jump from here to there. Okay, 33. Then
33.
again 2012, it was placed before DLC.
My lord.
Then it is recommended.
Recommended, my lord.
And then thereafter,
Thereafter, no, there is no communication from that, my lord.
no communication.
And my lord, they have filed one affidavit also, that is,
That was in 2015.
2015, my lord.
2010.
Past 2010, then state level committee was in 2014. Then
2000.
my lord, case
No, no.
33.
One is 2010.
Yes, my lord.
One is again 2012.
Yes, my lord.
2012. And when is the state level committee?
State level committee, case number 33, 2012-2014.
14.
Yes, my lord.
So there are two DLC.
Yes, two DLC, my lord.
2010, 2012.
Yes, my lord.
Then SLC.
SLC.
Then 2015 again DLC.
Yes, yes.
And recommended identified a post.
Yes, my lord.
Then thereafter no SLC.
No.
So what is the case?
And my lord, kindly see one, the affidavit of the respondent, my lord, that is paragraph 6, my lord. Para 2, my lord. The application was included minutes of the district level. The district level committee did not recommended the name. Whereas the district level committee recommended, my lord.
I directly about seeing it.
Okay, facts to a certain extent, I have.
No, Lordship,
Then in 2016.
no, Lordship, I can do two things. One thing is to get the instruction from the SLC, updated SLC, because after whether SLC has recommended or not recommended, at least that information I should get. If it is recommended, then well and good. And after that, if it is not recommended, then it is a case of delay.
Yes.
And then the delay from the government. side
Either
also-
from petitioner or from
Yeah,
government.
government delay from the government side also a delay. So let me take the instruction from the SLC, Lordship. What has happened to that after?
That statement appears to be wrong in the affidavit.
Lordship, I directly have seen this paragraph and I have stated because it's an affidavit, we are required to rely upon that, Lordship. So,
Heard Ms. Segan, learning counsel for the petition, and Mr. C.K.S. Borwell, learning junior government advocate Assam for the state response. Question. Now you are 52.
Yes, ma'am.
that is 52.
It is 2016, we have.
The
filed.
main,
2016, my lord, we approached the
Yeah, but-
court.
By that time pursuing litigation, you became 52.
Yes, ma'am.
What is left now?
it's not a matter of right, Lordship.
Take
Is
instruction.
there any kind of, can anything be, whether she can be appointed anywhere?
And she has already survived
Survived.
throughout all the years.
So I'll also I don't have any communication with that petitioner, my lord, so I'll take instruction, let them, because
Not please,
I don't have any-
52 now.
yes, my lord, 52, that is.
By
also
no way you can be appointed anywhere. Government, we cannot direct you, your appointment flouting the statutory rules.
Yes, my lord.
You cannot get appointment anywhere now. Over 50 now.
And the matter takes, I will also think what is the position of that lady, my lord, I also don't have any instruction.
Not
But
then how
still-
can you,
52, my lord, yes.
you have
that is
to,
also-
you have to go to Udalguri. 52, what can be done?
52-year-old lady.
It will mean 30, 40, okay. She has survived and she has survived since 2010, 15 years. 15 years. You are flogging a dead horse. No point. They never would have done it.
Up to your lordship, my. Up to your lordship, my.
No, no, I can't also, what consideration by SLC? Everybody will waste time.
Yes.
Is it not?
My lord,
SLC will be convened, even if I direct. And with that, what is the ultimate result? That lady has become 52 years. 15 years have gone by. Lady has survived. And how many sons and daughters you have? Have you disclosed or where is your application?
no, no, ma'am.
No, that is not.
No application. And you were 43. 43 means in 2016, 37. All your sons and daughters might have become major
Yes.
if you have.
My lord, let them produce the record whether SLC recommended or not, my lord, because.
Even if SLC recommended, it cannot receive judicial imprimatur now, 52.
Then up to your lordship, my lord.
If lady has already been appointed,
Yes.
No issue.
She has not given her joining letter. She
then
has
you are
not joined.
deprived of your material instruction.
She didn't join, my lord, that is fact, my lord.
When you were in contact lastly.
It's a relative of one of our chamber juniors, chamber mates, my lord, can contact, my lord.
When you were in contact lastly.
Last bit of contact.
Last, my lord. In 2000.
Lady might be,
Before COVID, before COVID.
21.
Mr. Borua, what do you get the instruction then?
I can get the answer. Only thing, Lordship, suppose if I get the answer, if I
she
get the
got
answer,
if she got the post,
if suppose SLC has recommended, but till now she has not given a joining report. So suppose tomorrow, say, after
Mr.
getting.
Gayon is not aware
Yes.
whether she has
So-
joined or not joined. If SLC has permitted, if she has been appointed, she may not contact Gayon.
Yes, man, that may
Right.
be happen.
That has happened to me many times,
Yes, man.
at least 50 times. That is a normal human conduct.
Yes, sir.
So you get the instructions. If she has been not,
Get instruction from that petitioner side also, my lord, from.
less possibility from your
Yes.
side. Mr. C.K.S. Borua. Right. State Council has submitted that whether he'll obtain instruction whether after being after the case of the petitioner was recommended by the district level committee on 9/11/2015. State level committee had considered the case of the petitioner or not. And if considered, the outcome. The outcome. Huh? Will not take much time to,
Yes, sir.
Yes.
next Tuesday.
Yes, sir.
This is the case on
Tuesday.
Tuesday. What you are? You are 50 plus now. Oh, this is, what about Sabir Hassan?
Sabir Hassan is, my lord, that is also.
What is this? This
He
is
is 28 years only, my lord.
Huh?
He is 28 at the time of filing this case, my lord. He is
Oh.
28 years, my lord. And then
2016. Then also almost 10 years. 38.
No good, no instruction, nothing. This is not going to serve any purpose. What was the case? Any DLC?
my lord, DLC, as per their statement, my lord, DLC was there, my lord. And his name was recommended in, as per the statement, my lord. This. In paragraph number 9, page 6, my lord.
It was returned, page 19. To the executive engineer in 2015.
He submit the proposal.
Proper form and other relevant document as per order of the Honorable High Court 2005. 1 each. Twelve. 7. 27. Okay, we'll come back and close this. No point.
Masudars.
Heard Ms. A. Gayan, done counsel for the petitioner. And Mr. JD is available. A. Fukan, non standing counsel. General Administrative Department. For the respondent number 1 entry, Mr. C.K.S. Borua. And Junior Government Bagrasam for the respondent number 2 entry. So, a petitioner has approached this court by the instance of the petition, seeking direction to the respondent authorities to consider his case for compassion appointment under the scheme framed by the state government. So, the case projected by the petitioner, in brief, is that the father of the petitioner, Fuad Hussain, was an employee under the Public Works Department, Government of Assam. and he died in harness on 11/12/2014 while serving in the post of peon in the office of the executive engineer, PWD, Guwahati, AACP division, Johannesburg, Guwahati. Postcode. At the time of his death, he left behind his wife, 2 sons and 1 daughter. Postcode. The petitioner was the, 1 son and 2 daughters. The petitioner was born on 7/1/2018 and he studied up to class 10. Full stop. The petition has stated that his father was the only breadwinner in the family, and at the sudden demise of his father, the family started facing financial constraints. Stop. Era. After the death of his father on 11/12/2014, the petitioner submitted an application before the respondent number 5 on 13/3/2015, seeking his appointment on compassionate ground in any grade 3 post. The application was duly received by the respondent number 5, and the same was also forwarded thereafter, to the office of the respondent number 4, along with the supporting documents on 27/3/2015. Poster. As when no communication was received from the respondent authorities as regards consideration of the case of the petitioner, the petitioner made queries at the offices of the respondent number 4 and the respondent number 5. Full stop. The petitioner came to know that the respondent number 4 returned back the proposal to the respondent number 5 in July 2015, stating that requesting the respondent number 5 to resubmit the proposal with proper format and other relevant documents within brackets, state certificate, application form, qualification certificate, etc. Poster. When no further communication was received by the petitioner, since then the petitioner has preferred the writ petition, seeking the mentioned direction, seeking the direction mentioned above. Post of Para Ms. Gayan, Learned Counsel for the petition, has fairly submitted that the petitioner, the C, is not in receipt of any up-to-date instructions. Full stop. No response has been filed by any of the respondent authorities. Full stop. Mr. Borua and State Council has submitted that he is also not in receipt of any up-to-date instruction in the matter. Where the purpose behind providing appointment on compassionate ground is to mitigate the hardship caused due to the death of the breadwinner in the family. Full stop. The policy of the state government for compassionate appointment is to be is to provide an employment immediately to redeem the family in distress. Full stop. The object of granting compassionate appointment is to enable the family of a deceased government employee to tide over the sudden crisis by providing a gainful employment to one of the dependents of the deceased who is eligible for such employment. Full stop. The law is settled that appointment on compassionate ground is given only for meeting the immediate unexpected hardship which is faced by the family by reason of the death of the brain earner. Full stop. Whereas in the state of West Bengal versus Debabrata Tiwari, reported in 2025, 5 SSC 712, the Honorable Supreme Court has laid down the following principles after considering a number of precedents, para 32 and 33. The employee concerned in this case died in harness on 11/12/2014. Full stop. A period of more than a decade has gone by. Full stop. The petitioner is found to have not pursued the matter very seriously since 2016. Full stop. A long lapse of time has occurred, and with the lapse of more than 14 years since 11/12/2024, the sense of immediacy for the purpose of securing appointment on compassionate ground is no longer there. Post of para in such view, in the above view, no matter, comma, this court is of a considered view that at this distant point of time, comma, no direction to consider the case of the petition for appointment of compassionate ground is called for. So consequently, comma, the petition is liable to be dismissed. It is accordingly ordered.
Also, please.
No cost. এইটো তো দিলো এটা ডেট এটা ডেট দিলো নাই মাতি দিও কি দিছিল The petitioner side is not there when called earlier. It is regarding some old pension scheme.
Yes, my lord.
Pension.
So I need to complete my instructions, my lord. Though I received some, my lord, but
It is for actually mediation.
yes.
During 2004. Is there any provision for writing the mobile number of the petitioner nowadays?
My lord,
Is there any provision for writing the contact number of the petitioner? The affidavit, let us see.
but I have
It is
that.
there.
Yes, my lord.
So mediator will contact,
Yes, my lord.
right?
Okay.
Mr.
Vidas, my lord, for APDC.
B. Das, I am standing on. For the respondent, APDCL authorities is present. The subject matter of the petition is a claim for pension under the old pension scheme, ES of the APDCL system. The is been listed, for the mediation. Okay, the element for settlement. So the land counsel for the petitioners is found absent today on call. Comma. It is noticed that the petitioner number 1 can be contacted at mobile number 8638-290-345. Silo over page 12 for the site very video, I can detail. And the mediator to ensure to make communication. The mediator is requested to contact the petitioner number 1 for the purpose of securing his appearance in the mediation process by contacting at his mobile number 1011. 10-9.
Bless me.
He passed in front of a file of
Was 13 to 16.
This matter pertains to selection and appointment to the post of Kampada in South Salmar, Mankesar district. In item number 13, Lordship, my Sharon's The selection of the respondent number 7 is on the ground. That initially I was selected, but after 4 and 5 hours, Lordship, they issued a corrigendum and my name was replaced. There was nothing, no minutes, anything on record, Lordship. Even Lordship on earlier occasion, they have produced the records, they could not show anything. And Lordship, simply my name was replaced and Lordship, he was supposed to be appointed.
Who are in
That I have
custody of
made
the
a,
records?
Lordship.
Who are in custody of the records?
Only the Lordship, the original records, Lordship, was once produced by my learned senior friend Torun Sutia. Thereafter, they are producing only the photocopies of something. Lordship.
Photocopy will
That,
not do.
that record is not forthcoming.
As per information, as per the information I have received, the record is here in the office, but today, Lordship, due to some this thing, records are not being sent. I have telephone informed them, Lordship, to send the records. If it is here, Lordship, we'll get in it some moment, Lordship. Lordship may take up the matter after some time or
Lordship, Lordship, may I submit?
Find
something?
out, yes.
Lordship. Subsequently, Lordship, I have come to know that another writ petition was filed challenging my selection, that is item number 16, in which Lordship, my learned friend who is appearing as Islam, who is appearing in the present writ petition, he appears on behalf of my client. So in item number 13, he is opposing my selection. In item number 16, he is defending his selection, Lordship.
You are one-
So,
one minute,
last
one minute.
occasion, Lordship, I have made a.
Nurul Islam Ahmed. You were,
Yes.
you were for Nurul Islam Ahmed.
Lordship will find one order, Lordship.
1 minute.
WBC.
1 minute, 1 minute. Nurul Islam Ahmed. This is your client.
Yes.
And who is the respondent here?
Respondent is Lordship, the Nur Islam Sheikh.
Nurul Islam Sheikh. So Mr. S. Islam appears for Nurul Islam Sheikh in item number 13.
13.
That is what you said.
Lordship.
Then
Then
what
Lordship will-
happened? And item number
16. Lordship will find that order I have.
Item
given
number?
in the. It is also there,
16.
yes, it is also there in the order, Lordship, in item number 13. The
What?
order is there in the record, Lordship.
one,
WBC 8394 of 2019.
item number 16.
Also.
Item number 16.
Yes.
the record I have received, Lordship.
Item number 16, who is the respondent?
Lordship, may I kindly see. I'm appearing for respondent 4 to. Lordship, I have placed one order dated.
I'll look into it, sir.
Yes, yes. Respondent number 15, Lordship.
Nurul Islam Ahmed.
Yes.
And there, Mr. Islam represents
No, it's not.
petitioner in item number 13.
And Lordship, I have taken proper instruction from my client that he has not given any power to anyone, Lordship, other than filing the writ petition at item number 13, Lordship.
Now, which order you said?
25/11/2019.
25,
11/2019.
25/11/2019. 25/11/2000.
That order is in item number 13 also, Lordship. I have given a copy.
In which order?
In item number 13, your Lordship will find that order.
You
25/11/2019.
want to say this order?
Yes.
This order?
Yes.
Is a long order?
Only the names are there, that is why.
Long.
Order is
okay,
very short.
Okay. Okay.
Page 22. Hard Mr. A.R. Bhuyan, Land Council appearing for the petitioners. Also Hard J. Hendrik, Land Standing Council, Revenue and Disaster Management Department, appearing for the response numbers 1. And Mr. S.S. Roy, Land Government Advocate Assam, appearing for the response number 2 and 3. And Mr. S. Islam, Land Council, appearing for a private respondent number 4 to 66. And this morning, Lordship, I have also tried to check the Wakalat number, Lordship, I could not find it in item number 16. Just to verify whether my signature is there. So this is a very serious issue, Lordship.
Huh? Details are same. Details are same, son of so and so.
Yes, yes.
Everything is same.
Yes, same selection process, Lordship.
Yes, sir. What to do?
Yes,
With
Lordship,
this kind of situation? We leave it to the council.
actually, say, it's a list of, it's a big list, Lordship. I'm finding the name of Mr. Nurul is, yes,
I have
there
seen
there are two person, 98 and 90, and Nurul Islam Sheikh is there, who is from village Bimbara, and Nurul Islam Ahmed is there, of the same village.
Okay,
Lot
let us
are also,
again, once again, we'll see, in the item number 13, Nurul Islam,
Lordship may see this,
son of Abdul Aziz, right? And his response number 35, you said?
Yes, Lordship.
No, 15.
15.
Abdul Aziz.
Yes.
Bhimpara.
Lordship.
Fuller sir.
Fuller, sir.
Bhimpara is additional.
yes, only the surname is different.
No, he's
No.
talking about something different, Lordship.
No, you are confusing. This is sound. Except Bhimpara,
Lordship.
everything is same.
Same. And
Yes.
And subsequently, Lordship, when my learned friends, Rahul Amin and others filed a complaint before the CM's vigilance, and all the 4 members of the selection committee, Lordship, they have been arrested.
Yes.
Including Lordship Atina
So
Sultana.
first, how to resolve this one?
Yes.
Regarding Mr.
Yes.
Islam.
Lordship.
This will be again. On the conduct, it is up to you. Person is same. It looks like, unless there are same, 2 persons by the same name, same father.
Mr. Sheikh and Ahmed.
No, Nurul Islam Ahmed. He is the petitioner in item number 13, and he is the respondent number 15 in item number 16.
Lordship,
Name
there-
same, father's name same, village same, police station same, district same.
Lordship, there is no dispute because 70 candidates, Lordship. In 3 cases, Lordship, there is individual sellers. I got a stay order in two cases, Lordship. 68 have been appointed. Only this Nurul Islam Ahmed and Nazrul Islam Sheikh in those 2 individual cases, they could not appoint because of the stay order operating.
Item now, his respond number, you said? Respond number?
No, item number 13,
Item number 16?
item number 13 and item number 15, Lordship, there are stay orders. These are individual challenges.
No, his respond number?
No, in the item number 13. Item number 13, Lordship, he is response number 7.
Item number 13? Nurul Islam Ahmed, son of Abdul Aziz, he is the petitioner in item number
13.
13.
13.
And respond number?
And response number 7 is Nurul Islam Sheikh. Because initially I was selected, my name was.
Let me get the
Yes, yes.
confusion cleared.
Yes.
Name.
Nurul Islam Sheikh, response number 7.
He is respond number?
7.
In the other one, 16.
Item number 13. Lordship,
Sir,
may I-
sir, please bear with me.
Lordship,
Nurul Islam Ahmed
Lordship,
is a petitioner
petitioner,
in item 13.
13.
And he is represented by you,
Lordship,
right?
Lordship,
And he is also a party in item number 16.
16.
What is his name, number?
Serial number 15, Lordship. Page 20. Page 20 of the report is.
Okay. Now, you are appearing in item number 13
Lordship.
and Mr. Islam appearing in item number 16. Is there any conflict?
Lordship.
Conflict.
Okay.
So how to resolve? There is a council, so I am putting it to you.
Lordship, that is why, Lordship, my prayer would be to call for the, because the Wakafnama is not here in the file record. I have seen in the morning.
Can you?
Only the petitioner's Wakafnama is there.
It was a petitioner and petition. You're a petitioner. Respondent to Kalama 9. Huh? Respondent to Kalama 9. Any office note, yes. Office note 3 16. The so and so has filed Kalasama. In affidavit on behalf of the document of file. 6. Where is your their affidavit in opposition?
It's any opposition. Affidavit opposition.
Private respondents affidavit in opposition. Four two. 67.
Yes, yes.
154.
My lord, in item
154.
No.
154. To 159.
Respondent numbers 4 to 67 tickets.
Affidavit in opposition has been filed, but there is no office note that Ukalanama has been filed. Yes, with what authority, Mr. Islam, you have filed the affidavit in opposition? For 4 to 67. There is nothing on record, perhaps, that you have entered appearance on by filing Ukalanama.
Take up, there is another case also. Have to check up really. There is another connected case for where representing that case 8 to 8.
Now, yes, Mr. State Counsel, shall we go ahead? Shall we go ahead with the petitions? Shall we proceed?
Today, Lordship.
Yes.
Lordship, Lordship, I need to examine the records, Lordship. Can Lordship take up the matter day after tomorrow?
Day after tomorrow, there are some other already been posted.
Because Lordship,
Which will
these
take a long time.
records only today it has come to my head, Lordship.
How many are petitioners who are deprived of?
Lordship.
Section filing is one.
Up to 70 losses,
60
they are 168.
60 yes.
In 2 cases losses, there are stay orders, they could not. In
How
item
many
number
posts were there?
70.
70.
Ultimately, it is 2 vacancies.
They
Ultimately,
could
it
not
is.
appoint losses.
Huh? No, let us go by law. If the vacancies are there, you cannot increase. So 70 vacancies, 68 were appointed. And you have also challenged their selection, right? And how many are in this total petitioners in this petition?
All of
Mr. Bhuya has 65. Plus Nurul, Mokibur, Nazrul. Total 68 claimants against 68 appointments.
Yes.
This is the position. Now, what is your primary ground of selling?
Also in Mokibur's case also, there is a stay order.
Not
operating.
Mokibul, that selection process, what are the defects you have found out?
Because this is prima facie lordship within 4 and 5 hours lordship, they have sensed the select list and come up with a new list without there any record lordship by their any office note. That has been reflected in the orders also. Because when the original records were produced, the Honorable Court was kind enough to show me the records. And I have noted down lordship.
Okay, Mr. Gorua,
Lordship.
do you have the original record?
No, the original records, Lordship, if I'm not mistaken, these are compared records. Lordship.
No, original records was produced by Torun Sutia lordship. Original record.
They check lower court case is going on, the original records are there. These are basically lordship, because the seal.
Any trial is going on.
Yeah.
Yes.
Charge sheet has already been filed.
Milord, what has happened, Milord?
No, you say or.
My
there's
lord, my-
Also background facts also.
Yes, yes,
Where
Milord,
criminal proceeding is going on.
my lord.
Criminal proceeding is going.
Milord, what has happened, Milord, during the pendency of these batch of petitions, Milord, a complaint had been lodged before the Chief Minister's Vigilance Cell, Milord. And that it turned out to be a charge sheet, Milord, and that charge sheet has already been laid before the
These are
Honorable
contested
Special Court,
cases.
Milord. So, Milord, that trial is now commencing, Milord.
Yes, yes, yes.
That is my updated instruction, Milord, and basing on the charge sheet also, Milord, we have also filed a writ petition that is not, Milord, tagged together, Milord, today, Milord.
For what? That is for what?
Because, Milord, as they have already been, Milord, charge sheeted, the entire selection process has been held to be vitiated in law in that charge sheet, Milord. So therefore, Milord, we have relied on that.
Privacy case.
Prima facie, Milord,
Not-
but,
That
my-
cannot be.
but, Milord, trial is
Which
going
can-
on,
Define it.
my lord, my lord. But the position is that
Whether these documents or records you have, what kind of authenticity can be given
Authenticity
to
basically-
these documents
These are
to adjudicate these petitions?
Lordship, basically what I'm saying, Lordship, along with these documents, just before the two letter we have received, what it has stated that I am trying to inform you that a letter under reference so and so, the Revenue Disaster Management seeking status of CM Vigilance case number, since the instant case was registered at Vigilant PS Assam, which is under disposal, therefore letter along with enclosure is forwarded to a good office for necessary action from your end. This is the letter, Lordship. I am directed to forward here the information I received from the SP, Chief Minister Vigilance Cell for information and necessary action. And the information here, Lordship, Vigilant PS case number has already been charge sheeted and forwarded to the Honorable Court of Special Justice Assam. There is so all seized documents and relevant case records along with the case diary in connection with all the referred case has already been submitted before the Honorable Court of Special Justice Assam in the year 2022 and 2023. The status of trial of special case Soins of 2021, order dated 30/1/2025, passed by the Honorable Special Judge in connection with special case is enclosed here. It is
Why it has been forwarded by special judge?
yes, also. Basically, the status of the trial of the special case, Lordship.
But that will not do.
And
So when was the charge sheet submitted?
charge sheet was and forwarded to the Honorable dated 29/11/2021.
Do you have the copy of the charge sheet?
One charge sheet copy I have lost.
Yeah, Lordship.
Find out the
Yes,
last
charge sheet
few
is in the
pages.
record, Lordship.
Find out the last few pages, list of the.
Yes, yes, charge sheet is here.
Last few list of documents to be relied, if it is a vigilance case, at least they will file a charge sheet in a proper manner.
Lordship,
Like no normal, IO.
Lordship, it was filed on 29/11.
See the last few pages, list
21.
of documents to be relied upon.
Yes, sir.
oh, sorry. Next or 7 o'clock.
29. Tamil-
Yeah, please send it over.
Yes.
Which one is more? 35
This
copies.
is pertaining to two other officers. Lordship.
That we have received from.
35 copy.
This is certificate copy.
But if can we compare to the detail?
How many persons have been seated?
Lordship, in that case, Lordship, 2 persons.
The names are.
Vikram Aditya Bora and Lordship, one.
Huh?
Vikram Aditya Bora and Lordship, Cyber Rahman. The Cyber Rahman in another search. Vikram Aditya Bora and the person.
Seat number 2.
Namket Asir.
And there is a supplementary
Seat number
certificate
2.
in respect of
Same.
Atika Filter.
আমারটা ওটা রেকর্ডটা আছে
Two persons.
2 persons.
Oh, 2 circle officers.
2 circle. They were the members of the selection committee. And one supplementary search.
And it appears the volume of documents seized are voluminous. Voluminous.
Lordship.
So how to go ahead?
Fix for hearing.
How to go ahead then? The documents are voluminous from the charge sheet it appears.
So we'll try our best to assist your lordship while in regard to disposing.
Because the annexer 1A,
Lordship.
there are so many files,
Lordship.
about 10 files.
Yes, yes, yes. So lordship may kindly fix the matter on a short note lordship and
Whatever document you have, you find out
yes lordship.
whether this can be proceeded with.
Yes.
It can be proceeded, we will proceed. Irrespective of the criminal trial, that will take a long time. So many witnesses are there.
Lordship.
That will take about 5-6 years.
And Lordship, my learned
List of
friend,
witnesses I have seen.
respond number 7, perhaps he has already over. He could not be appointed. Respond number 7 in item number 13.
You 68 petitioners. Need only replacement of respondent number 7 or all?
And Lordship, he wants replacement of all.
He needs replacement of all
Yes.
by them.
Yes.
It is not only one.
Not only one. Entire selection. He has challenged the entire selection.
Yes,
Entire selection.
68 persons were appointed and petitioners are 68. And they are challenging the other 68 appointments.
Other list.
Is it not? And any glaring illegality?
Lord, it is a
Glaring.
glaring, my lord, from the inquiry as well as the material could collect, my lord. My lord, we will try to make an attempt to satisfy my lord that the illegality is there. And the, my lord, it's the cash for job scam. My lord. That is there, my lord, in the charge sheet.
That is different thing here for job. So far, Mr. Porua. Mr. Hendrik, you care for whom?
For number 1. And my lord,
Basically, it is the district commissioner who?
all the selection appointment done by the deputy.
Circle officer under deputy commissioner.
All of the.
Whether sufficiency of materials to defend the case are available or not with you?
Sufficient document lordship, I think proper affidavits has not been filed, I guess, although we have got the records. So that yeah, proper affidavits we have not filed in the matter.
Within opposition.
And I think only one circle officer has filed an affidavit in item number 13 and 14 we have not filed.
108 to 1.
I did not file.
108.
I did not one.
There was
108. Who has filed the affidavit in opposition?
One affidavit in item number
The-
16, where the circle officer has filed.
In item 13, any official
Item number
respondents have
13.
filed their affidavit?
Yes.
Huh?
They have filed those.
Which one?
102.
102. Respondent number 2.
Number 2. LDA. in the Commissioner Lower Assam Division.
Deposit Borua, special officer.
DC ফালৰ পৰা এখন affidavit আহিব লাগিব।
Okay, in item number 16. Why this man has been made a respondent?
Selected, my lord.
By the corrigendum, he has been removed.
No, my lord.
He was not able.
Ah,
That is the reason.
so
That was issued subsequently.
that was somebody else. His name should have been different.
That's correct, my lord.
Huh?
My lord,
Because I'm trying to find
Yes,
out,
yes.
my lord, the select list, which we
because item number. The stand of the official respondent is that Nurul Islam Sheikh has been selected by way of corrigendum in place of Nurul Ahmed, right?
Yes.
Maybe under a misconception, Mr. Islam might have filed the Wakalatnama for Nurul Islam Sheikh, right? He was maybe under a misconception. And since Mr. Bhuiyan has wrongly implemented Nurul Islam Ahmed as the respondent number 35 or 15.
Because, my lord, they.
And similarly, Mr. Islam might have been misguided by all of the similarity in names. First mistake committed by Mr. Bhuiyan without looking into the corrigendum, because he may not be aware of the corrigendum. It could happen, right?
Because, my lord, I relied the select list.
Better you clarify this situation. Otherwise, otherwise between you and Islam,
I'm also not blaming my learned friend, my lord.
Ah.
It's a bona fide and inadvertent mistake.
maybe because you also by mistake,
My lord. They're not
without
person
having the
to blame.
knowledge, you might have implemented him
Right.
as respondent of so-and-so because you are not aware of the corrigendum maybe. And Mr. Islam might have been guided by that,
That-
that he is appearing for Nurul Islam Sheikh. Whereas,
They're different, father's names are
but
different.
no, that confusion is to be clear, no? Because you have, first point you have made the submission on that point. And I got confused and I also got confused.
And
Now-
the names are almost same, only the surname is different.
Only different, so you have implemented him.
My lord.
Whereas he is a non-selected candidate, he should have been by your side.
By my side.
He's already has filed a petition.
Correct, my lord.
So this is the situation.
Lordship, in this writ petition.
So far one person is concerned, Nurul Islam
Ahmed, my lord.
Sheikh should have been your respondent
Item serial number.
in 16,
My lord.
right?
My lord.
That would have been,
No problem, my lord. Pardon me.
are you appearing for Nurul Islam Sheikh?
Sheikh.
Mr. You correct it
My lord.
by way of an IA. So everything will be no impropriety on the part of any of the council. then.
My learned friend is saying now.
Huh?
My lord, I have been blamed by my friend now. It's my
Yes.
No,
Yes, yes.
I'm not blaming him.
No, because the confusion.
confusion.
Because your first point of submission was there.
Because in this writ petition.
I was
their
taken
stand
aback.
is- their stand
I
is
thought
also
that
this.
Mr. Islam had committed some impropriety. But mistake was from Mr. Bhuiyan. So you get it corrected so that he can continue with the same Wakalatnama.
Yes, yes.
Or wherever it is. And everything will be
It's
clear.
not available on record.
You are a deprived person.
Yes.
This Sheikh is not a deprived person.
But he
He's a selected person.
Yes.
So he'll his name will be corrected in the
Cost title.
cost title, and Mr. Islam will continue to represent him.
That will be easy for.
Things should be cleared. Most easy way is to file a
IMA.
by because of not having knowledge about the corrigendum, mistakenly similarity in names, then everything will be cleared. Then thereafter 68 versus 68.
That Wakalnama is also not in the right.
Not required then, we're not required. Because you are a deprived person, Sheikh is not a deprived person.
And also annexure 19, the coordinate annex in it.
So Mr. Bhuya will do it. I'll not say anything. It is ultimately it is this. And Mr. Borua, if you can you get your instruction about sufficiency of materials?
Worship.
That will do. You should do it soon. Then your challenge will remain. His challenge will also remain. Then the confusion will be cleared about Mr. Islam, and we can proceed. Because nowadays either you have to make an amended cost title or whatever process. We cannot do it now.
No, we don't.
Nowadays we cannot do it.
I'll. And my learned friend should not be in trouble, Milo. For bona fide mistake.
He is not required.
In item number 13 and 15, there are interim orders. In item
All
number
interim orders.
13 and
continue.
15. Only 13 and 15.
13 and
13 and 15 was.
13 and 15. Okay. Heard Mr. S.K. Das, learned counsel for the petitioners in 13 and 15. Oh, 13, 14 and 15. Mr. A.R. Bhuyan, learned counsel for the petitioners in 16. Mr. J. Hendrick, learned standing counsel Revenue Department. And Mr. C.K.S. Borua, learned Union Government Advocate for the official respondents. First of also heard Mr. S. Islam, learned counsel for the respondent number 4267 in 16.
I think.
And the private respondent number
7.
Private respondent in sole private respondent
Sole.
in 13, 14 and 15.
That's number 7.
Right? During the course of deliberation, a confusion regarding one of the respondents in item number 13 and item number 31 WC and 16 have arisen, and the learned counsel for the parties have submitted that necessary pleading be filed to clear the confusion. Within a week's time?
My lord.
Within a week's time. So, Mr. Borua, learned Union Government Advocate, paying for the state respondents, shall obtain instruction as regards availability of original records of selection. So, Mr. Borua has submitted that the original records of selection might be before the special court.
No, sir.
Before the special court as
Spell vigilance corridor.
before the special court as a charge sheet has been submitted. In connection with which case number?
CM Special Vigilance Case number 5 of 20.
5 of 2021.
21.
5 of 2021 on
Seated on Milo, date to side. 29/11/2021.
against
Number quota special.
against two public servants
Oh, you go. Number quota special does.
involved in the selection process
My lord.
under reference. And
In this case,
the original records might be in the custody of the special court. So he will obtain instruction from the eye of the case whether if the original records of selections are in the are before the trial court, compared copies of the records of selection can be obtained from the IO. That will do. IO will get it compared copy from them. That will do. These files are there. Few files are there.
These are basically photostat copies, not compared copies. So we will get these are basically photostat copies, not
Compared
compared.
copy. We cannot go on compared copy certified. We cannot go. I have already ruled myself to Brahmanim Swami case that
Certificate copy to law.
these are hearsay evidence. How can I proceed? I cannot proceed. Other court can proceed. I cannot proceed.
Lordship, interim order is the IPO.
Interim orders passed in
Item
13
13 and 15.
and 14.
15.
12, 15. 12
সময়
continue
লাগিব।
till the next date of
লাগিব।
release the cases on
So it will take some time.
after puja on a fixed date.
Possible.
I'm sorry.
Yes, sir.
At next item, Milord, item is 17, Milord. So regarding maintainability question, I'm not feeling good, Milord, in this matter. Look, can it be on any date in this week, Milord? My learned friends.
Next Tuesday, Lordship.
Okay, I have shortlisted.
Yes, Milord. I have also done some homework, Milord. I like to place on written argument in check, Milord, in this matter. Division bench of which our courts has discussed this point, Milord. That judgment I could place by written argument, Milord. Any date, Milord.
On the
9th.
prayer of Mr. P.K. Dekka, Learned Counsel for the petition, and Mr. S.S. Roy, Learned Central Government Counsel for the respondents, release the case. We'll find out.
Yes,
Ninth.
Milord.
We'll get a fixed date.
Yes,
We'll
Milord.
find out.
Yep, yep. Obliged, Milord.
Your lordship, can I matter with Asaba for the time being?
Who is for a respondent?
May it please your lordship. Your lordship, I am praying for some accommodation in this matter today, your lordship. Your lordship, we have filed an additional affidavit in this matter today itself. Additional affidavit we have filed today itself. That is
Today?
perhaps, yes, your lordship. That is perhaps not in the record. So now 2 weeks' time may be granted, your.
Okay, Mr.
A Das, your lordship, on behalf
A.
of
Das.
GN Saheba.
Learned Counsel, appearing for the petitioners,
20.
has submitted that an additional affidavit on behalf of the petitioners
Addition.
has been submitted today, and the said affidavit on additional affidavit is not on record. So he has sought for listing of the cases after 2 weeks. So State Council, Mr. CKS Borough and government appearing for the state has submitted that he has no objection to it. So I sought for raise the cases after 2 weeks on a date to effect by the office. The additional affidavit must need to have been filed. Take command record.
My lord, there is an interim protection.
The interim order passed earlier shall continue till the next date of this.
Obliged.
Item number 29.
May I please, your lordship?
Madam, matter pertains to suspension of the petition.
Based on some judgment? Judgment is. Yes.
Madam, in this case, petitioner was suspended on 20th November 2024. That is annexure 1,
8 November
2024.
Suspension. Yes.
And thereafter, my lord,
Where is the order?
that is at annexure one, my lord, page 30. There was some anomaly in issuance of ration card in respect of Dhubri district.
You are superintendent.
And my lord, he was superintendent.
Hmm.
মইতো পারমিশন
Food
দিয়া
and
নাই
Civil
মই যেতিয়া
Supplies
মই যেতিয়া
Department.
সোমাইছো
So, he was placed on the
আমাৰতো
suspension.
মইতো আগৰ পৰা নাই মই পিছতহে সোমাইছো
Thereafter,
বাহিৰলৈ জুনিয়ৰ
Yes.
thereafter, my lord, that annexure two, my lord, page 35, was issued with the memorandum of charge, my lord. This is so-called notice. This is dated 10/1/2025, 10/1, 10th of January,
Hmm.
2025,
Memorandum.
memorandum of charge. So it is issued within the period of 3 months, my lord. So as per direction of Honorable Supreme Court in Ajoy Chaudhury's case,
Hmm.
my lord, currency of a suspension order
Hmm.
will not extend the period of 3 months if within 3 months the memorandum of charge is not. And then there is another part, second part of that direction. Even if by lord within 3 months the memorandum of charge is issued, a reasoned order has to be passed extending the suspension. But in this case, that reasoned order has not been passed.
Okay, that is your specific ground of challenge.
That is the specific ground of challenge.
This
And-
is Annexure Roman 2. Then you replied.
Yes, thereafter, my lord, annexure 3,
Annexure 3,
at page 38, we replied to the charges.
page 38.
Then in his reply, he has stated that all these were done online and he is no way connected because he did not have this password.
What is Annexure 4?
Annexure 4 is my lord. He has filed an appeal
Appeal against suspension.
against suspension. Against suspension. So in this appeal also no order was passed. So he had, by this annexure 4 dated 20th of March 2025, he prayed that suspension should be revoked. But no order was passed on this application. Then my lord, annexure 5 at page 55. So this order was issued on 6/6/2025. That is after a period of 6 months. And by this order, the suspension order has been extended for another 3 months by giving retrospective effect. This order is dated 6/6/2025 at page 55.
Let us read it.
Yes, whereas Ashok Sharma, Superintendent of Food and Civil Dhubri, was placed on the suspension with effect from 20th November 2024 by notification number so and so, whereas departmental proceeding was drawn up against Ashok Sharma, Superintendent of Food and Civil, by so-called notice so and so, whereas considering the grave nature of charge against Sri Ashok Sharma, the disciplinary authority has decided that reinstatement as this stage may not be in the interest of public service. Now, therefore, Governor of Assam is pleased to extend the suspension period in respect of Sri Ashok Sharma, Superintendent of Food Public Distribution and Consumer Affairs for a further period of 3 months with effect from 28/5/2025 or till further order. So now this order is issued on 6/6/2025 and it gave the effect, a retrospective effect. That is from 28/5/2025. The significance of 28/5/2025 is that on that day, 6 months period comes to an end. So now as per government notification, that is at Annexure 7, page 60. This notification was issued as per direction of Honorable Supreme Court in Ajoy Chaudhary's case. And there was a High Court, our High Court also, Honorable High Court also in WPC number 6467 passed some direction, and thereafter this notification was issued 4th February 2020 at page 60, my lord. I'm reading the paragraph second onward. It is therefore directed that all the senior most secretaries of all departments shall ensure that memorandum of charge sheet is served on the delinquent officer employee before the expiry of 3 months of period from the date of issuance of order of suspension. They shall also ensure that currency of the suspension order should not extend beyond 3 months. If within this period, the memorandum of charge sheet is not served on the delinquent officer employee, if the memorandum of charge sheet is served within 3 months of suspension, a reasoned order must be passed for the extension of suspension wherever necessary. Wherever necessary means if the order is extended, then a reasoned order has to be passed. And if it is not extended, then definitely the employee will be reinstated. So now, in this case, no reasoned order was passed within the period of 3 months. And thereafter, then another order has to be passed. The officer proposing for suspension shall also ensure that the charges are framed, submitted to the disciplinary authority within 2 weeks from the date of passing order of suspension. After issuance of memorandum of charge sheet, the senior most secretary shall undertake a review within 6 months as regard the desirability to further continue with the suspension order. So in this case, the review order was also passed after 6 months and giving it a retrospective effect.
Review order?
Review order, my lord. That is the extension order. Review order is dated. That is Annexure 5. Annexure 5 at page 55. That order is dated 6/6/2025.
That is beyond 6 months.
That is beyond 6 months. So that is why they have given retrospective effect. Retrospective effect from 28/5/2025. So that is the significance of that date, my lord. Because on 28/5/2025, that 6 months period came to an end.
So what is their additional affidavit? What is there?
Oh, in additional affidavit, we have filed that now they have again passed an order extending the period for, because during this period, the 3 months, other 3 months period is also about to come to an end. So now, this time within a period of 3 months, they have issued another order extending. But initial order has already been elapsed. Well, that is not in currency. The subsequent order of extending the suspension will not extend it. Because as of now, the suspension order has lost its force.
What is their reply?
In their reply, they have taken a stand that they have initiated the review process within the period of 6 months. But the order ultimately came out after of expiry of 6 months.
Which let us see their stand.
Para number 7.
Paragraph 7 of their affidavit.
The memorandum of charges.
That the deponent begs to state that as per personal department office, the memorandum of charges is to be served on the delinquent officer employee before the expiry of 3 months of period from the date of issuance of date of order of suspension. The currency of the suspension is not to extend beyond 3 months if within this period the memorandum of charges is not served on the officer employee. Is served within 3 months of a regent order must be passed for the extension of the suspension, wherever after issuance of the memorandum, the senior most secretary is now
Contemplating to rescind, is it?
Yes.
This is as part of OM. This is as part of OM.
that's for the way. That is para 8. Para 8. That the deponent begs to state that the process for review of his suspension order was initiated well before expiry of 6 months period following due procedure and with the approval of the competent authority. After review of the matter by the disciplinary authority, the suspension period of the petitioner under suspension was extended for a period of 3 months with effect from 28/5/2000 till further order by notification number 7 months. That is dated 6/6/2020.
Yes. Basically, Lordship, what Ajak Mach already says, Lordship, if within the 3 months period, a charge sheet is not being framed, then Lordship, this suspension goes. And within 3 months, the memorandum of charges is been framed, then Lordship, at the end of 3 months, if the suspension is required to be continued, then Lordship, it is required to be extended back by review order. Lordship, now Lordship, after that, this government OM is there, where it says of 2020 that the law is that within 3 months, if we are able to frame the charges, then we can keep him suspended from 6 months. And at the end of 6 months, Lordship, extension, yes.
Interpretation given to this other Chaudhary and.
Yes, Adok Chaudhary also similar, but thing is that Lordship, here Lordship.
Region order.
Yeah, and yes, Annexure 5 year, 28 November 2024, the suspension he was kept. And Lordship, for this thing was being done, extension was being done on 28/5/2025, exactly on the last day of 6 months, if I'm not.
28/5.
28 November 2024 is a suspension, 28/5/2025. If I'm not wrong, then I think that is the last date of the 6 months.
There is a difference between extension and renewal.
And in the
Extension has to be done within the currency. Renewal can be done beyond the currency also.
it is on the last date of the last.
Consistently, I think there is no doubt. You're swimming against the tide.
Lordship, let me do one thing. Let me get the record, Lordship.
What record? I have seen the expressly apparent from the order and your affidavit in opposition.
And
And that is very consistently interpreted. And this is, interpretation is also binding on me.
May I place two judgment from our High Court?
You have seen, Ajay Chaudhary.
Following Ajay Chaudhary.
Vinayam Krishna.
Vinay Krishna, then Dr. A.K. Odhyapak, Honorable Justice Suman Shyam. he has laid down some rules of general principle.
Both are wrong. Even if you assume that there is region order. Let us assume for a moment. Then 4th February office memorandum that within 6 months.
Yes, my lord.
That is also has
Definitely.
gone beyond 6 months.
They have given retrospective effect.
Retrospective, no. Extension
So they
cannot
know
be.
the importance of 6 months. That is why they have given retrospective. So, and my lord, this person is going to return in the month of September 30th. No, October 30th. September 30th.
Lordship, there is a judgment, Lordship, of Sudhir Kumar Paul, Lordship. Lordship, today I don't have the hard copy of that. Otherwise,
We'll
there's-
get the hard copy,
Yes, Lord.
WBC number.
WPC number 5623 of June 24 of this court, Lordship. 5623 of 24.
Yes.
Here at para number 7, Lordship, the 6-month thing is also mentioned that it manages issuance of will undertake review within 6 months as regard the desirability for further continuance with a suspension order.
Paragraph 7.
713. 10.
Division.
Basically here, stress has been given on 6 months this thing. The review has to be take place on. Topic of one whole. 6 বেশি দূর হয়েছে 6 বেশি দূর হয়েছে মানে 28-5 পৰা 6-6 গেপটো কেনেকৈ এক্সপ্লেইন কৰিব
রেকি বুলি নামে ঠুকে this interpretation
Worship.
That interpretation in this judgment, I have gone through it.
But again it is
Rightly.
6 months
Huh?
again it will be that's
No, this, because, Rekipudin Ahmed, plus, there is one more judgment.
Rekipudin
Individual
Ahmed,
bench
Department, I have-
authored by me.
A division bench judgment, where
Ah.
my lord,
And there is another, division bench judgment on the same point authored by me.
para 15.
4খন মান আহি গ'ল এটা
This appears to be par inferium.
Although issue Dhuri would be
ছমাহৰ
applicable
ভিতৰত কৰিব ন ছমাহৰ বাহিৰত হলে
in respect of 1964 rules.
আৰু এটা মোৰ
Paragraph 15. It is asked in respect of deemed suspension. After arrest of the person.
This is what? This is,
In respect of a deemed suspension, after arrest of a person.
It's a suspension under rule 6-1,
6-2.
6-1A. Itu আপোনাৰে happy
this is
দিছো।
what? We are into what? 6-1A.
No,
6-1A.
we are into 6-1A.
No, সেইটো আপোনাৰ synopsis এটা। আপোনাৰ synopsis টো চাওক।
There is one more, IIT is involved. IIT.
Yes, another
Where is that?
is there.
It's 6-1A তলতে হ'ব। Double one.
He has been to analyze and push.
Yes, Rakibuddin Ahmed. Although Chaudhary was followed,
Yes,
whatever principle is laid down in 6-1
yes,
is also applicable in 6-2
yes,
for deemed suspension.
Lordship,
And periodic review within a period of 6 months.
Lordship.
Away from this, in the judgment,
No, that is it. Here only that 6 months is given.
no, 3 months. Rakibuddin says 3 months.
And it
Rakibuddin says 3 months. While deciding the principle, it says, in our view, the issue should be seen from the perspective of the consequence and effect of suspension, which is the same in both the cases. We also feel that no prejudice whatsoever would be caused to the department by such interpretation, inasmuch as no blanket order of revocation of suspension is passed. It is left to the department to make periodical review within a period of 3 months and decide as to whether such suspension is required to be extended or not by assigning regions.
yes, 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 Lordship.
Whether such regions are justified or germane can be the subject matter of a separate silence. In view of the aforesaid discussion, we answer the reference by holding that the principles laid down in the case of Ajoy Kumar Chaudhary would also be applicable in case of deemed suspension under section 6-2 of the 1964 rules. Both 6-1, 6-2, Ajoy Chaudhary is applicable. Then how can this, that 6 months, this
No,
appears to be a mis-
even if 6
appears to
months,
be a min-
even if-
revision order must be there.
even if 6 months, this annexer file,
Because this review,
Lordship.
because senior most secretary may not be the disciplinary authority.
Okay, competent authority.
One may be an appointing authority or
One may
disciplinary
be a-
authority.
Lordship.
And law is also there, controlling authority
Lordship.
can also suspend a person,
Lordship,
right?
Lordship.
Then this 6 months review is by a senior most secretary in the department. He may not be the appointing authority or disciplinary authority. But
Lordship.
review for extension of suspension period is to be done by the authority who has passed the order of suspension. But this
Here,
This
here it is
this-
secretary.
Because the judgment which he has annexed, that has cleared the position. The judgment of Honorable Justice A.M. Bujar Borua. Pursuant to that,
This notification was issued.
Now that is clear in page 59. This
The
interpretation.
authority has to be same.
Perhaps Rakibuddin Ahmed has been perhaps misinterpreted.
Although Lordship in Annexure 5, there is no explanation of the gap period from 28/5 to 6/6/25. That part is there, Lordship.
The instant writ petition under Article 226 of the Constitution of India is preferred to assail. Please take your seat. An order dated 28/11/2024. Passed by the respondent number 3. No, sir. Whereby the petitioner was placed under suspension with immediate effect, comma, and another order dated 6/6/2025. Passed again by the respondent number 3, whereby the period of suspension of the petitioner was extended for a further period of 3 months. WEF 28/5/2025 or till further order. Full stop. A direction in the nature of directions in the nature of mandamus. Direction in the nature of mandamus has also been sought for. For a direction to the respondent authorities to reinstate the petitioner into service with immediate effect. Full stop. Para. The petitioner is an employee under the, why you said erstwhile food and public distribution? He is an employee under the Food, Public Distribution and Consumer Affairs Department. Full stop. At a time of passing the time of issuance of the order of suspension dated 28/11/2024, comma, the petitioner was serving as a superintendent, comma, food, comma, public distribution and consumer affairs, comma, Dhuburi, at Dhuburi. Full stop. Para. It transpires that it was reported that the number of ration cards in Dhubri district number of issued ration cards in Dhubri district had been unreasonably inflated. So stop. As per the report, comma, in 5 legislative assembly constituencies of Dhubri district, comma, selection of new beneficiaries were undertaken for issuance of new ration cards under the NFSA 2013. And during the said process, comma, the ration cards issued were found inflated. A pattern of manipulation in selection of new beneficiaries was observed with a number of families consisting of 2 members only. And the same seemed inconsistent with the demographic pattern of Dhubri district. Full stop. The petitioner was found primarily responsible for such manipulation. And it was alleged that he was apparently, it had been done apparently by him with malafide intention. In such backdrop, comma, the order of suspension dated 28/11/2024 came to be passed by the respondent number 3. In exercise of the powers conferred by sub-rule 1 within bracket small a of Rule 6 of the Assam Services within bracket Discipline and Appeal bracket rules 1964 within bracket quote unquote 1964 rules 1960 or the rules 90 for short. The petitioner was placed under suspension with immediate effect, and the headquarters of the petitioner was made at Dhubri with a further direction that the petitioner would not leave the headquarters without obtaining prior permission from the district commissioner to post. Para. At this stage, comma, it is relevant to mention the facts which are not in dispute. Full stop. After placing the petitioner under suspension on and from 28/11/2024, comma, a show cause notice under Rule 9 of the 1964 rules read with Article 311 came to be issued, came to be served, had been served upon the petitioner, directing him to show cause as to why disciplinary proceedings should not be initiated against him, and as to why any of the penalties prescribed in Rule 9 of the 1964 rules should not be imposed, inflicted upon him. Full stop. A statement of allegation was also enclosed with the so-called notice for the, it would deliver 10/1/2025, huh? With a show-cause notice dated 10/1/2025, along with a list of witnesses and a list of documents. Full stop. In response to the show-cause notice and a statement of allegation, served upon the petition on 10/1/2025, the petitioner submitted a reply to the respondent number 3 on 17/3/2025. Full stop. Assailing the order of suspension dated 28/11/2024. The petitioner also preferred an appeal before the state government on 20/03/2025, praying for revocation of the order of suspension. Full stop. Para. The impugn order no, it was on 6/6/2025. The impugn order whereby the period of suspension of the petitioner came to be extended for a further period of 3 months, WEF 28/5/2025, or till further order came to be passed by the respondent number 3. Full stop. It was mentioned that considering the grave nature of charges framed against the petitioner, the disciplinary authority had decided that reinstatement of the petition at that stage might not be in the interest of public service. Full stop. In the above backdrop, the petitioner has instituted the instant writ petition seeking the reliefs mentioned above. Full stop. Mr. Murali Learned, I have heard Mr. S. Murali Learned, counsel for the petitioner, and Mr. C.K.S. Boru, Learned Junior Government Advocate, Assam, for all the respondents. Full stop. But Mr. Murali has contended that the order of suspension dated 28/11/2024 came to be passed by the respondent number 3 in exercise of powers under Rule 6 within bracket 1 in bracket small a of the 1964 rules. And a subsequent order extending a period of suspension came to be issued only on 6/6/2025, whereby a period of suspension was extended with retrospective effect from 28/5/2025. Post of, he has pointed out that in between 28/11/2024 and 6/6/2025, the disciplinary authority or and stroke or the competent authority did not make any review of the suspension order within a period of 3 months from 28/11/2024. Full stop. As there was no region order. Full stop. He has submitted that even if the memorandum of charges is prepared and served upon the delinquent official, it is still a necessity. It is still amended to review the suspension order within a period of 3 months to find out the necessity to extend the currency of the order of suspension. Full stop. He has submitted that neither within a period of 3 months nor within a period of 6 months from 28/11/2024 any review was done. Full stop. It is evident from the order dated 6/6/2025. The review was done only after expiry of a period of 6 months from 28/11/2000. Full stop. In such view of the matter, in such view of the matter, neither the original order of suspension passed on 28/11/2024 can survive any longer, nor the subsequent order dated 6/6/2025 is sustainable and proper. Full stop. In support of his submission, he has relied upon the decisions of the Honorable Supreme Court in Ajay Kumar Chaudhary versus Sorenso and an order and a judgment of this Honorable Court, a judgment of a division bench of this court in Rekibuddin Ahmed versus the state of Assam and others. It must be reported somewhere. It is reported. Rekibuddin is reported. On the other hand, Mr. Borua, learned Union government appearing for the respondent. State response, has submitted that as per the as per an office memorandum dated 4/2/2020, comma, the memorandum of charges is required to be served upon the delinquent employee within a period of 3 months. And the said condition has been fulfilled in the case in hand. As the memorandum of charges was issued and served upon the petitioner on 10/1/2020, which was within a period of 3 months from 28/11/2020. To stop. The office memorandum has further stipulated that after issuance of memorandum of charges, comma, and a review is required to be undertaken within a period of 6 months to find out the desirability to continue with the suspension or not. Full stop. By referring to the stand taken in the affidavit in opposition, filed by the respondent number 3, Mr. Borua has submitted that the process for reviewing the suspension order passed in respect of the petitioner was initiated well before expiry of 6 months period following due procedure and with the approval of the competent authority. Full stop. After review of the matter by the disciplinary authority, comma, the suspension period of the petitioner was extended for a further period of 3 months, WEF 2025, or till further order, right? The impugned order dated 6/6/2000 and support yes. Refer to a decision of a coordinate bench of this court in WPC 5623/2024, within brackets Sudhir Kumar Paul of the state of Assam, comma, decided on 12/6/2025. Full stop. Some discipline. The matter of suspension, that the power to place a government servant under suspension has been provided in Sub-Rule 1 of Rule 6 of the Rules 1964. And so, in the following manner. 6(1)(2)(1)(a)(c). No, 6(1) and 6 has been provided in Rule 6 of the Rules 1964. For the purpose of the case in hand, Sub-Rule 1 and Sub-Rule 2 of Rule 6 are relevant and therefore some same are quoted. 10 below for edit. Better. The Honorable Supreme Court in Ajay Kumar Chaudhary versus Union of India, Supra, has laid down the law that the currency of paragraph 21 also, that the currency of a suspension order should not extend beyond 3 months if within the said period of 3 months, the memorandum of charges stroke charge sheet is not served on the delinquent officer stroke employee, semicolon. If the memorandum of charges stroke charge sheet is served, comma, a region order must be passed for the extension of the suspension. Full stop. From a plain reading of the law so laid down in Ajay Kumar Chaudhary, comma, it is discernible that the law so laid down is in two parts. Comma, firstly, comma, contemplating a situation wherein a disciplinary proceeding has not been initiated against the delinquent officer stroke employee within a period of 3 months with effect from the date of suspension. With effect from the date, such officer stroke employee was placed under suspension contemplates two situations. First situation contemplates, is it? In such situation, comma, it has been laid down that the currency of the suspension period shall not extend beyond 3 months. If within this, if within the initial period of 3 months, the memorandum of charges stroke charge sheet is not served upon the delinquent officer stroke it is not a this situation is not involved in the case in hand, as after the order of suspension dated 28/11/2024, comma, the memorandum of charge was issued and served upon the petitioner within a period of 3 months. That is, comma, on 10/1/2025. Full stop. Comma, the second situation in Ajay Kumar Chaudhary contains a mandate that in the event the memorandum of charges stroke charge sheet is issued and served upon the delinquent officer stroke employee within a period of 3 months from the date of suspension, Even then, a region order must be passed for extension of the suspension period beyond the initial period of 3 months. Question. Para. At this juncture, comma, the relevant parts of the office memorandum dated 4/2/2020 issued by the state government in the personal department, comma, which is holding the field as on date, comma, can be adverted to page 60. Yes to this. Comma, from a bare reading of the aforequoted parts of the office memorandum dated 4/2/2020, comma, it is evident that even if the memorandum of charges stroke charge sheet is served within 3 months of suspension, comma, a region order must be passed for the extension of the suspension wherever necessary. Full stop. The office memorandum has further mentioned that after issuance of memorandum of charges stroke charge sheet, comma, the senior most secretaries shall undertake a review within a period of 6 months as regards the desirability to further continue with the suspension order. Full stop. The office memorandum has further envisages that the senior most secretaries will be held responsible if cases of suspension in their respective departments are not dealt with and reviewed accordingly. Full stop. Para. The submission advanced on behalf of the official respondent that it is a senior most secretary in the department who is only mandated to undertake a review within a period of 6 months. Is found not acceptable. For a reason that both in Ajay Kumar Chaudhary Supra and in the office memorandum, it has been clearly laid down that it has been clearly set forth that if the memorandum of charges stroke charge sheet is served within a period of 3 months from the date of suspension, a region order must be passed for the extension of the suspension. First, the senior most secretary of a department may not be the disciplining authority, stroke appointing authority or controlling authority who has passed the order of suspension. And it is the appointing authority stroke disciplinary authority or controlling authority who has passed the order of suspension, has been mandated, has been cast with the obligation to review the period of suspension within a period of 3 months. The senior most secretary may be in some situation, the senior most secretary may at best maybe the appellate authority. Para. It is also settled that for extending the currency of an order, the order for extension has to be passed during the currency of the said order. Therefore, currency of an order is not to be passed for extending its period is not to be passed after the period is over. From such standpoint, the order dated 6/6/2025, whereby the period of suspension the suspension period six 2000. The suspension period of 3 months was extended. The suspension of the petitioner was extended beyond the period of 3 months is not found sustainable. If the period of 3 months from 28/11/2024 expired on when? 27.
No,
In February, it will.
In February 2025.
if 3 months,
3 months.
if you consider 3 months.
28 or 3 months?
If you consider 3 months, if you
In
consider.
February 2025. In February 2025. Full stop. The authority, the authority who had passed the order of suspension, that is the response number 3, ought to have passed a region order within a period of 3 months from 28/11/2024. Full stop. No material has been placed before this court, and nothing has been contended that any region order was passed within a period of 3 months from 28/11/2024 to extend the currency of the suspension period beyond 3 months. Full stop. The order dated 6 This is 6-8 or what? Sorry.
6-1.
55, I'm sorry, I'm sorry.
6-6-25.
55. Page 55?
Page 50, page 55. Also, we have annexed in our affidavit, Lordship.
Please below the signature.
As annex ID.
The impugn order dated 6/6/2025. Oh, sorry, there was, there was no order. No valid order extending the period of suspension for the period from 3 months to 6 months, which expired on 28/5/2025. So, therefore, the order dated 6/6/2025 could not have been full stop, para. In the in light of the discussion made above and for the regions assigned, this court finds that a right has accrued to the petitioner for seeking a direction for his reinstatement in his service on account of the fact that due to non-passing, due to failure on the part of the competent authority to pass a region order within a period of 3 months from 28/11/2024. The period of suspension beyond 3 months from 28/11/2002. Right has accrued on, and the period of suspension beyond a period of 3 months from 28/11/2024. So it is found to be invalid and honest in law. Having noticed in view of the law declared in a matter in the case of Ajoy Kumar Chaudhary Supra and implemented by the state respondents to the office memorandum dated 4/2/2020, the subsequent reviews carried out for extending the period of suspension, also for extending the currency of the suspension period pursuant to the order dated 28/11/2024 would be of no consequence. Full stop. The division bench in Rakibuddin Ahmed has observed that has noticed that the decision in Ajay Kumar Chaudhary was with regard to a case where suspension order was issued pending trial of disciplinary proceeding. Which is akin to a suspension order passed under Rule 6 within bracket 1 within bracket A of the 1964 rules. Comma. And then not a case of deemed suspension. Which comes into place, which comes into effect under Rule 6(2) of the 1964 rules. Full stop. The division bench in Rekibuni Ahmed Supra has held that the principles laid down in Ajay Kumar Chaudhary cannot be restricted to an order of suspension issued only on contemplation of trial of disciplinary proceeding and not for deemed suspension. First of examining the issue from the perspective of consequence and effect of suspension, the division bench has observed that the consequence and effect of suspension is same in both the cases. And therefore, comma, it is incumbent on the department to make periodic review within a period of 3 months to decide whether the suspension period is required to be extended or not by assigning regions. Full stop. In view of the decision in Rekibuni Ahmed, comma, the principle laid down in Ajay Kumar Chaudhary is found applicable both for matter of suspensions issued both under Rule 6(1) and Rule 6(2) of the 1964 rules. In view of such position, comma, the decision in Sudhir Kumar Paul Supra, placed by Mr. Borwal and State Council, does not require any discussion. Full stop. Para. The order of suspension passed in respect of petition not having been reviewed in terms of the directions passed by the Honorable Supreme Court. In the case of Ajay Kumar Chaudhary Supra and the office memorandum dated so and so Supra, this court is of the unhesitant view, that the same has lost its force, and accordingly, comma, the same cannot be said to be in currency any further. Full stop. Consequently, comma, the petitioner is required to be reinstated in his service. Full stop. Accordingly, comma, It is directed that the respondent authorities shall reinstate the petitioner in his service within a period of 15 days from the date of receipt or a certified copy of the report. Para. If the respondent authorities are find that if the respondent authorities find that the continuation of the petition in the post of superintendent so and so might be prejudicial. To the might be prejudicial. Is prejudicial to the is against the public interest and administrative exigency. And the post is of a sensitive nature, comma. Following the observations made in Ajay Kumar Chaudhary. In paragraph 21, command, the respondent authorities would be at liberty to transfer the petitioner so as to sever any local or personal contact that he may have and which he might misuse for obstructing the investigation against him. If any, investigation, comma, if any, against him. So, in other words, comma, the respondent authorities are at liberty to reinstate the petitioner and thereafter transfer him to keep him out of the mischief's range. The repetition stands allowed to the extent no cost.
Lordship, I have a small prayer, Lordship. Lordship, item 20 to 29, Lordship, 28, Lordship, this has been adjourned, Lordship, for 2 weeks. Lordship, actually, I have a prayer with for a vacation of stay, Lordship, stay order.
Stay order.
Yes, Lordship.
They have submitted one additional pleading today. Some
Lordship.
additional affidavit, that is their submission.
Uh,
And that is not on record. And you were not there, nobody was there. I had
no,
to-
actually, Lordship, I just,
What can I do?
yes, Lordship. So I just pray, Lordship, kindly fix it next week, Lordship, any day, like next Tuesday.
I cannot, you bring the person who made the mention.
Otherwise,
I'll
this
definitely-
is, they are not even the government employees, Lordship. They are challenging, because of stay, Lordship, they are enjoying.
You should have put someone as proxy. I didn't know. I never
Even the appeal also
examine
filed by
when.
even they filed the appeal, Lordship, writ appeal, when the court was supposed to dismiss it, they have withdrawn the appeal also. So,
Okay, we can, what can do immediately after the head for you, immediately after. But after 2 weeks, make a mention. Already I have passed.
he
the-
mentioned, Lordship.
Because the other council is not available. Not Mr. Sahel or ADAS, Mr. ADAS.
Yes,
He
Lordship.
made a mention.
Informed us that they want to take the adjournment.
We don't know. We believe in council.
Lordship.
Yes. And you can get you into 9, right? Oh, what, 3? Yes, madam.
Lordship, the next item, absolute parameteria, the facts are what Lordship was just taking up.
Mr. Patwari has been given,
My only,
Patwari has been given the time.
Sir, Lordship, understand that. In the instant matter, what had happened was the proceeding is already complete. And on the last occasion, the KL, my learned, had, in fact, told the court that they will perhaps have a decision on the entire process. Although I'm still under suspension. But the inquiry is complete and the report was expected in a day or two. Today, I am told that the report is, although it is complete and it has also been, orders have been passed, but it can only be opened by the Vice Chancellor of the university, who is not available today. So my learned friend wanted to take a very short adjournment and fix the matter perhaps next Tuesday, subject to your Lordship's opinions. And
Yes, series, Kiki series. Use the series that you fix kora.
Tuesday.
Sit with 10.
The
11th, your lordship, possible. 8 and 9, Mr. Kyal will.
Let me.
Yes.
Huh? Huh? Kiki আছে, কি চুরি এটা আছে। Firewood. Put that one. Yes, one matter, long matter was there. And 2 other matters, but one involving Advocate General. Some 300 appointments in assistant engineer.
if the report available, then it perhaps will not be, won't take much time.
Okay, we'll put
Otherwise-
it on Wednesday.
Lordship, witness, some person, I am traveling to Defu for 11th Thursday.
11th.
Because it was fixed for a, no, day otherwise, for proposal at the.
11th not possible, madam. We have seen.
Then
What is?
Then Monday, your Lordship.
Yes. Hint.
Lordship.
In RHO. Petitioner. And Miss
P. Upadhyay, your lordship, on
P.
behalf
Upadhyay.
of Mr. S.C. Kyal.
and Council. Representing Miss Assam University.
Yes, your lordship.
Are present as sought for an inquiry learning council for the party list that on 15/9.
Deeply obliged.
Obliged, your lordship.
Yes, Mr. Patwari. Oh, Mr. Bora. Mr. Bora Kodibu Lego Pram. I didn't coding. Oh, sorry, Mr. Bora. Somehow accidentally, actually, I did not know that your case was listed today, Mr. Bora, Pran Bora. Actually, I did not know. Yesterday, I gave him that I'll take up his case first. You need not have to wait. I'll fix the date. Well, thereafter, I will reserve. I have to hear you on some points. So thereafter, I will reserve the judgment, right? On one particular day, we'll find out. Next week.
Next week.
Today, Adi ki day? Adi Mangalbar day. Thursday, you are available.
Yes, sir.
We'll make an attempt.
At my last.
We'll hear you half an hour on the point. That all these 70
Yes,
just.
10-15 minutes.
Ah.
10-15, not more than.
Here Thursday, fine. The Pran Bora. Item number 30. Yes, I have to make more reports
Yes, my lord.
or covered.
My lord is covered almost.
My lord, the petitioner was suspended on 15/6.
Let me have the file.
Yes.
No review, Lordship.
Huh?
Admittedly, no review was done till today, and no charge sheet was filed within 90 days. Otherwise, Lordship, and departmental inquiry is completed. It is before the highest authority to decide.
Put him
that.
somewhere else.
Otherwise, Lordship,
Put him somewhere else. I am
Lordship,
saying.
Lordship, my prayer is, Lordship may direct the respondent authority to take a call on a final decision.
Which one?
Lordship, in that inquiry report. Lordship, annexed.
Suspension order,
Page 19.
reinstatement, subsistence allowance. These are the prayer.
Yes.
We are
Yes,
not
yes.
going beyond it.
Yes.
Yes, Lordship.
It is always open for you.
Lordship, my prayer is, Lordship.
Why need a direction from the court to take a decision on the
Lordship,
final
Lordship.
report?
In a
That is your jurisdiction.
Lordship, Lordship. Otherwise, in a similar facts, Lordship, the coordinate benches passes order, Lordship. So on similar ground, Lordship. He was the party petitioner was there, Lordship. He was.
A direction which is uncalled for, I will not pass.
Other Lordship.
Where you have the authority and jurisdiction, we should not remind you to exercise the jurisdiction.
Para 18 onward, Lordship.
If the disciplinary proceeding is concluded, they are at liberty to take appropriate decision.
That is my prayer, Lordship.
You have the power. Court has transferred upon the jurisdiction, no?
No. And otherwise, Lordship, after Ajoy Chaudhary, one judgment was passed by Honorable Supreme Court, Lordship. In that case, also, Lordship did not interpret the suspension order, Lordship. Justice. Yes, Lordship.
In this case, my lord, facts are different. The petitioner did not participate in the departmental proceeding. He deliberately delayed. Here, my lord, I participated. I have given my reply. And my lord, the inquiry report was submitted in the month of last year, August. Second so-called reply filed on, it was served upon me on April 2025.
Let us see the facts first.
Yes, my lord, yes.
Instead of going into.
Yes, instead of piecemeal basis, Lordship will kindly. Lordship will kindly take the dates, my lord.
List of this.
Lordship will kindly.
Okay, let
take
us see the facts first.
Yes, Lordship will kindly take the dates. My lord, petitioner while serving as the land record assistant.
Which is the order?
My lord, page
Lot
nine-
Mondal.
Yes, page
Nowadays, land record assistant.
Yes.
Yes, Lordship.
Okay.
Page 19 is the suspension order.
Pending trial.
26 months ago. Suspension still going on.
15/6.
15/6/23. 26 months have elapsed, my lord. No review, no extension till then. Then, my lord, memorandum of.
That is, your case is Rekubuddin.
No, my lord, my case is as a Chaudhary, para 21. 3 months, no review.
No,
Now-
your case is deemed suspension
No, my lord, the order does not reflect.
of
so.
pending trial.
6-1. My lord, thereafter, no review, no extension till date, though 26 months.
You
of
got
it.
arrested or what?
Yes, I got arrested in connection with ACB PS case number 43 of 23 on same day, 15/6/23.
When you were arrested?
15/6/23, same date. Like.
Same date. Arrest.
In connection with ACB PS case number 43 of 23.
Then bail?
Yes, my lord, bail was granted.
15/7.
Yes, my lord.
15-7.
Annexure 2, page 20. Then after expiry of 3 months on 29/11, so-called notice issued. Page 23, my lord.
Page 23.
On 29/11/23, that is much beyond the permissible limit of 3 months, so-called notice was issued.
So cause.
I filed my reply immediately on 13/12/2023. Page 28, my reply.
Reply.
My reply at page 28.
Ah.
13/12/23, I filed my reply. My lord, thereafter, if being not satisfied, my lord, inquiry officer appointed, departmental proceeding proceeded. And my lord, on 23/4/2025, I was served with a copy of the inquiry report. That is the second.
1 minute, your reply is page?
Reply is my lord,
28.
page 28. Second,
Then
then page 31, second so-called notice.
why second circle?
My lord, the inquiry report is furnished to me.
Okay. What is this then?
Page
Here
31.
in the office, other side,
This will be another some round of litigation. They have expressed their mind in the second so-called notice without even giving me the chance to my lord.
23/4.
25.
23/4/25. 25.
23rd of April.
Inquiry report.
Inquiry report was submitted on my lord 21/8/2024. That was communicated to me on 23/4/25.
21/8/2024.
Yes, 21/8/2024 is the inquiry report. That is annexed at page 33. Page 33. Date is there, my lord, on the top.
Oh.
Page 33.
Or I am satisfied to know that I conducted people in a believe
They cannot, there should be another round of litigation, my lord. So I am not in that. So they waited so many months to, now, my lord. After
Where
that,
from inquiry report was submitted, okay.
Yes.
21/8.
Thereafter, my lord, at page 42, thereafter, my lord, I submitted my reply on 3/5/2025 to the second so-called notice. Page 37. So now
37, reply.
my reply to the second so-called notice. 35/2025. And till now, nothing has been done. More than 26 months have elapsed. No review, no extension. I am still under suspension. So, my lord, I will straight away rely on 2 decisions of this honorable court as well as other Chaudhary's case.
What is their reply?
My lord, in their reply, they have stated.
Let us have a look just.
Yes, their reply, Lordship will kindly see para 9 at page.
Para 5.
No, para 9 at page 48. Running page 48. Their affidavit in opposition. The deponent.
Anything about where we pleaded that no review
Let's say para 5 we have stated, Lordship.
in the writ petition?
Oh, in the writ petition, yes, ma'am. My lord will kindly see para.
I see.
Para 15, my lord. And 17 also. Para 15 and 17.
What are the annexes they have annexed?
My lord, they have annexed that now the disciplinary authority has changed. And they are saying that, my lord, that since the inquiry report has been submitted, we should wait for the outcome. Lordship will not interfere with the suspension order. That is their stand categorical. At para 9 of Well, affidavit in opposition. Para 9 at page 48 of their affidavit.
Para?
9 of page 48, my lord, their affidavit. Running page 48. Yes. Para 9 of their counter affidavit. Filed by one Lasit Kumar Das.
So you maintain complete silence or what? Regarding review?
Lordship, para 5. Para
Para
5
five.
affidavit, Lordships.
Para 5.
No review was done, Lordship.
Hmm?
No review was done, admittedly, Lordship.
Till today.
Page 46. Could not be served upon a petitioner within
Within
time.
90 days.
And review of suspension could not be taken up.
Lordship, Lordship. Admitted position, Lordship. That is-
Admitted position.
Lordship.
So what Supreme Court?
The Supreme Court says the Lordship. That is how. Para 50 onwards, Lordship. No, admitted by
Para
50.
50.
50 onwards, Lordship. Para 22 of other schedule has been discussed.
He did not participate.
Lordship, but last three line, Lordship. Ratio is most probably that is. In any case, we find that the issue of prolonged suspension would be taken care by directing the departmental proceeding to be completed within a stipulated period. But the suspension of respondent number 1 would continue till then. We find that the impugned judgment passed by the High Court is not sustainable in law. In the result, the appeals are allowed in the following terms. The
See
impugned
the facts then.
facts that they are challenging the authority who is, yes, Lordship. para 13, Lordship. That may be one of the ground is that within 90 days, they have not served us charge sheet or memorandum of charges. Para 13. Right. Yes.
Review or non-review was not an issue.
Yeah, but there is that no, one of
Not
the
an
issues.
issue at all.
One of the issues is that within 90 days, they have not served the charge sheet, Lordship. Para 13, Lordship. Para 13, last 1, 2, 3, 3 line. He
But
submitted.
the
that-
High Court,
Lordship,
High Court decided
Lordship.
on the authority who was competent to
Competent to,
suspend or not to
not as-
suspend. Ajoy Chaudhary was never discussed.
In High Court,
High
Lordship.
Court.
Before the Supreme Court, they took this play, Lordship.
Because that was not an issue at all.
Para 13, Lordship.
Because it was, because the SLP
Lordship.
was preferred by the
The
employer.
authority, employer, Lordship.
Right.
Yes, yes.
And in that connection,
Supreme Court, that plea was
Yes.
taken.
his counsel, delinquents counsel made an argument that in view of Ajoy Chaudhary, I am
Entitled to reinstatement.
that context. He was not the
Not-
counsel. And it was not his argument. He challenged the authority and power to place him under suspension.
Lordship, para 13, Lordship, maybe. Last 4
This-
lines,
this
Lordship. He
is-
submitted that in any case, in view of the judgment of
This is
this
by
court.
Anupam Lal Das.
Lordship,
And he is appearing for a delinquent,
Lordship,
right? He made the submission for Ajoy Chaudhary.
Lordship.
When the employer,
Goes to the Supreme Court.
Supreme Court, and he said, whatever, power, jurisdiction, forget about it. Because of Anupam Chaudhary, sorry, Ajoy
Ajoy
Chaudhary,
Chaudhary.
I should be in place.
Yes, sir.
But he challenged the
That also.
competency of the authority to place him under suspension.
That has,
Right.
the honorable court has discussed.
See paragraph 14. Let us read paragraph 14.
The High Court in the impugned judgment has held that since the appointment of respondent number 1 was made by the state government in view of the section 36 of the MMC Act, it is only the state government who was competent to suspend and initiate departmental inquiry against him. It was therefore held that suspension order issued by the commissioner and ratified by KDM Corporation and departmental inquiry initiated by commissioner with the approval of the KDM Corporation was beyond their power.
That was the
Issue, Lordship.
issue.
But
Ajoy
Lordship-
Chaudhary was never issued, but he tried to defend
Lordship,
that
Lordship,
because of Ajoy Chaudhary, whatever is happened, I should be in service.
Lordship,
That was not the issue,
Issue,
his
but-
repetition.
Lordship, my humble understanding is that para 50 onwards, that honorable
Para
court has,
50 is a different issue.
para 50 onwards, the court's finding was
see.
that, Lordship. Court finding of that.
But he
And-
needs challenge, somebody has to challenge that review was not done.
Lordship.
That
On the-
is why I asked Mr. Patwari, where is your ground
Lordship.
that you have preferred this repetition regarding review or not? And I asked you,
Yes.
and you have admitted
Admitted.
clearly
Admitted
in
for
your
the Lordship.
affidavit. And that is not the issue there.
Following this, does not.
He never asked for review, but he should be reinstated because there was no review.
Lordship.
He challenged the authority and jurisdiction of the authority who passed the suspension order, that you are not my authority. So this is non-est in law. He admitted your jurisdiction. Yes, you have the power to suspend. But to extend it beyond 3 months, you have to follow certain procedure.
Lordship.
If you follow that procedure, he is out. If you do not follow the procedure, he is in.
Lordship.
That is all.
That is Lordship. The following that does not Lordship, that Pradeep will I have submitted. This was passed Lordship. Yes, Lordship. Paragraph 20 Lordship.
So you take a final call.
Lordship.
Lordship, I'll give the Lordship permits rather. Just two decisions I want to play. My lord, there is a division bench order authored by your Lordship, reported in 2019 5 KLT, page 444. I should kindly peruse one paragraph of that.
Yes, Mr. Rahman. I don't think your case can be taken up. Huh? I am dictating this order, Alvi. I'll be dictating this order, so. Okay, we'll put it on 15 then. Okay. Item number? 32. Over your opposing counsel? Okay. You are, any state council is there? H. Raman, state council is said by Mr.
Actually inform. Yes, Lordship, record are with you.
Present. You were still by Mr. Asroman. You were there. Assignment. And council for a petitioner and Ms. M. Morrissey. And state council for this. The case. And agreed to parallel for the party is the case on 15-9. 15-9. Yes.
Yes, my lord, this is a division bench order on suspension and your lordship has been pleased to author it. And lordship straight away come to paragraph 15 of that judgment, my lord. May I read it, my lord? The state government definitely has the power, authority and jurisdiction to keep a government servant under suspension pending trial of disciplinary proceeding or during the pendency of a disciplinary proceeding, during the pendency of a criminal investigation, inquiry, trial. The object of placing a government servant under suspension is to keep him away from an influential position wherefrom he can interfere with the conduct of the disciplinary proceeding, pending or contemplated, all criminal investigation, inquiry, trial, so as to prevent him from hampering the process of collection of evidence or from tampering with the evidence in any manner or where, having regard to the nature of charges, allegations against him, the competent authority is of the opinion that it would be unsafe to continue to vest in him the power of the post the government servant is occupying. It is for the competent authority to consider all these aspects, at the same time placing government servant under suspension and also during the period of suspension for keeping him under suspension. At the same time, on the other hand, placement of a government servant under suspension for a prolonged period unduly would change the color of measure taken to place the public servant under suspension with the aforesaid objective into a measure of punishment. In my case, my lord, more than 26 months have passed. So it's a clear case of prolonged suspension without any review, and it has turned into a measure of punishment. And as regards my learned friend's contention that now disciplinary proceeding is in the final stage, my lord, there is a judgment court of a coordinate bench of our court. Same argument was advanced that the suspension should not be interfered with. And the citation is 2017 3 GLT.
And that
Page
has been
27.
given to us. Some mention is there, I think.
Yes, yes. Lordship will kindly come to.
1 minute, 1 minute.
Yes.
Just by going through this, Bhumidhar does.
Yes, that Pradeep Kalita judgment is a part. Lordship.
Yes, that there I have cited that, my.
Yes, Lordship. That was considered Lordship Pradeep Kalita.
Yes.
Yes, my lord, para 11 at page 29.
So in neither of the cases, it is a proposition that just because disciplinary proceeding is pending,
and the coordinate based judgment he is relying
that he should be
absolutely correct.
Only this judgment is there.
No,
Supreme Court,
but
which
there is no ratio laid down by. This is under the facts and circumstances of that case.
Every tax is different, Lordship.
So let's
He has relied, but otherwise, so far after inquiry report, disciplinary authority is at full liberty to take its own decision. If he is sitting over the matter, what can we do? Let him sit over the matter for next 4 or 5 years.
I don't have temper or wait a quick.
We are not here to give sermon to them.
My lord, that para 11 is interesting of Bhumidhar Das. What's reading, man? Page 29, para 11, line from 1, 5, 7th line, my lord, para 11, as noticed, as your lordship got it. As noticed, the petitioner has been in suspension since 3/11/14, and it is well over 2.5 years now that the respondent authorities have been unable to conclude the disciplinary proceeding. In such circumstances, I find no justification for the prolonged suspension of the petitioner. My lord, this is important. Even if the disciplinary authority ultimately decides against the petitioner, there is no reason as to why the petitioner should be kept under suspension awaiting such final decision. But this is what I was trying to impress upon your lord.
So he decides to do it over the matter, let him continue for next 5 years also.
I'm sorry, Lordship. That's it. May I
Spending government money.
rely on again
Reply to
Lordship.
reply.
Para 18 of the para Pradeep Kalita judgment. Para 18 of the Pradeep. Just read. As noted above, the inquiry proceeding is in this case has already been concluded an inquiry officer has also submitted his
I
report.
read.
Lordship.
I record that these are the facts not in dispute. That inquiry officer has submitted on his
Investigation.
inquiry
On
report
21/8/2024.
21/8/2024.
Yes.
Then after waiting for 6 months.
8 months.
Lordship.
8 months, the disciplinary authority has forwarded his report. Should we include more? That proposing a punishment or penalty?
Yeah.
Huh? What he has done, I have seen
Lordship.
that, what?
Predetermination of guilt.
He has already put the cart before the horse. That penalty is, I am going to impose. Dismissal. Then after that, now it is almost 5 months.
5 months.
The present petition under Article 226 of the Constitution of India is preferred inter alia to assail a suspension order dated 15/19.06/2011, 2023. And for a direction to the respondent authorities to reinstate the petition in service by revoking the suspension order dated 15/06/2023. Are you getting the substantial allowance? No.
I am getting at 50%. So that is a prayer.
The direction has also been sought for grant of enhanced suspension subsistence allowance at 75% for a period beyond initial 3 months, as the petitioner has only been paid subsistence allowance at 50% till the date of deferring the repeat. The facts will backdrop. Under which the repetition has been preferred can be narrated, include, at first. The petitioner is petitioner, on 15/6/2023, was serving as a lot mondal, within bracket presently, land
record assistant.
Land record assistant. Under Uragaon Revenue Circle, District Morigaon. Postal. For allegedly accepting bribe amount of rupees 20,000. The petitioner came to be arrested on 15/6/2023. Stop. The proceeding of the TREP proceeding was contemplated in view of the complaint by one Faizuddin. Before the Deputy Commissioner Moriga on 8/6/2023. On the basis of the complaint lodged by Faizuddin, a case ACB Police Station case number 43/2023 was registered and the petitioner was arrested. During the course of investigation of ACB PS poster on an application filed for bail, the special judge, the Court of Special Justice, Assam, Guwahati, after hearing the parties, learned counsel for the parties, allowed the prayer for bail by an order dated 15/7/2000. Para. As soon as the petitioner came to be arrested on 15/6/2023, the respondent number 2, that is the Deputy Commissioner Moriga, passed the impugn order of suspension on 15/6/2023 itself, pending trial of disciplinary proceeding. The order of suspension was made in exercise of the powers conferred on respondent number 2 under the Armed Services Routine Discipline and Appeal Rules 9. Rules per rule. The order of suspension further mentioned that the suspension would come into effect with immediate effect. And the same was passed following receipt of evidence that the petitioner indulged in his demeanor in the capacity of a public servant. Where subsequent to placing the petition under suspension on 15/6/2026, the Director of Land Records, okay, the response number 3.
Page 23, madam.
Being the disciplinary authority, right?
Yes, sir.
Of the petitioner. Issued and served a memorandum of charges upon the petitioner under Rule 9 of the Rules 1964. Read with Article 311 of the Constitution of India, asking the petitioner as to why any of the penalties prescribed in Rule 7 of the 1964 rules shall not be inflicted upon him on the charges, mentioned therein, based on the statement of imputation, allegation attached thereto. Stop. With the show cause notice dated, I should date the book 29/11/2000. With the show cause notice dated 29/11/2020, a statement of allegation, a list of witnesses, and a list of documents were annexed. Full stop. The petitioner was asked to submit his written statement of defense within a period of 10 days from the date of receipt of the memorandum of show cause notice. Full stop. In response, the petitioner as a delinquent employee submitted a reply on 13/12/2023 refuting the allegations made in the show cause notice. Full stop. In the subsequent period, an inquiry officer and a presenting officer came to be appointed, right?
Yes, ma'am.
And disciplinary proceeding proceeded. Full stop. The petitioner has stated that he had duly participated in the disciplinary proceedings. Full stop. The inquiry officer, upon completion of the inquiry, submitted an inquiry report on 21/8/2024. Before the disciplinary authority. That is the response number 3. So on submission of the inquiry report, on receipt of the inquiry report, the response number 3 as the disciplinary authority forwarded a copy of the inquiry report to the delinquent employee, that is the petitioner. For affording the delinquent employee stroke petitioner an opportunity to submit his representation. We'll put it here, we'll not go into that aspect.
That will be a subject matter of another litigation. This will be a subject matter of another litigation.
It will be sudden death. On receipt of the copy of the inquiry report, the petitioner responded by way of a representation on 3/5/2020. We forwarded the copy on
23/4/25.
3/4/2000.
23/4.
First of After receipt of after receipt of the representation by the, by the respondent number 3, as the disciplinary authority, comma, the disciplinary authority, no, sorry, the respondent number 3, by a communication dated 23/5/2025, apprised the respondent number 1 that had forwarded the inquiry report along with the documented evidence for information and to obtain concurrence from the competent authority for early disposal of the disciplinary proceeding.
This was communicated on the basis of letter dated 27/5/2024. That is annexure E, Lordship, page 59.
Lordship will kindly see the conduct, no signature. No signature in the document. Till annex and then petition. No signature. What kind of conduct is?
Para. In the backdrop of the above, comma, the issues contentious raised by the advanced by the learned counsel for the parties are required to be considered. Poster. Para. I have heard Mr. J. Paturi, learned counsel for the petitioner. Mr. S. Doctor, learned standing counsel, Revenue and Disaster Management Department for the respondent number 1 and 3. And Ms. M. Bhattacharya, learned additional senior government advocate for the respondent number 2. Full stop. Para Mr. Patwari, learned counsel preparing for the petitioner, has submitted that the impugned order of suspension was passed on 15/6/2023. And the writ petition was filed on 30/07/2025, that is, after a lapse of 2 years from the date of suspension. He has contended that though the petitioner came to be arrested in connection with ACB police station case number 43/2023, the impugned order of suspension was passed pending trial of disciplinary proceeding. And therefore, it appears, it is discernible that the impugned order was passed in exercise of the powers conferred by Rule 6(1)(a) of the 1964 rule. She has further submitted that the petitioner as a delinquent employee had participated at every stage of the disciplinary proceeding, which culminated into an inquiry report on 21/8/2024. Full stop. It is his contention that the original, initial period of 3 months. So after expiry of a period of 3 months from the order of suspension dated 15/6/2023, neither the respondent number 2 nor the respondent number 3 had reviewed the order, reviewed the matter of suspension in order to extend the currency of the suspension period. Close stop. In the absence, and he has further submitted that a memorandum of charges that was prepared and served upon the petitioner by Soko's notice dated 29/11/2023, which was also beyond a period of 3 months from 15/6/2023. Full stop. He has placed reliance in the decision of the Honorable Supreme Court of India in Ajoy, Chaudhary and Supra, more particularly, paragraph 21 thereof, to contend that in view of the failure on the part of the combined failure on the part of the respondent number 2 and the respondent number 3, either to review the matter of suspension or to issue the memorandum of charge within a period of 3 months. The period of suspension beyond the initial period of 3 months from 15/6/2023. Sorry, beyond the period of suspension is to be treated as non-est in law and invalid. Yes, further submitted that in view of the petitioner's prolonged period of suspension of about
26,
more than 26 months till date, comma, the matter of suspension has changed its color to a measure of punishment. He has referred to a decision of this court in division bench of this court in State of Nagaland versus Subbanusang Inchan, 2019-5, DLT 444. Pera. Suman hai agar to by koi diyo. Follow it up. Mr. Dotto has one standing also. Revenue and Disaster Management Department has submitted that the allegations leveled against the petitioner in ACB Police Station case number 43/2023 are grievous in nature. Full stop. He has submitted that whether the criminal proceedings in connection with ACB arising out of ACB Police Station case number 43/2023 has been completed or not. Not aware. He has fairly submitted that. Insofar as the disciplinary proceeding initiated against the petitioner is concerned, he has further submitted that. Insofar as the disciplinary proceeding initiated against the petitioner is concerned, the proceeding has reached the stage of receipt of inquiry report by the disciplinary authority, and the matter is under consideration of the disciplinary authority at present. First of. He has submitted that since the inquiry has already been concluded, resulting in an inquiry report, resulting in submission of an inquiry report as about on 21/8/2024. And the matter is pending before the competent authority for taking appropriate decision in the matter in accordance with law, no interference with the matter of suspension at this stage is called for. Full stop. In support of his submissions, he has referred to a decision of a coordinate bench in WP series petition number 5966/2024 within the gate Pradeep Kolita versus State of Assam and others. And Kolyan and of the Honorable Supreme Court of India in Koilan, Dombi Valley Municipal Corporation versus Sanjay Gajanan Bharat and others reported in
AIR 2022 SC 1618. Top of the line.
2022 INSC 377. I find very difficult to read Monu.
Yes, ma'am.
2022 INSC 377. SCC 94. There is no SCC.
AIR logic. Second line logic. Equivalent citation.
Right to Nayama INSC like first of. He is also author the Mr. Paturi has also submitted that the actions and omissions on the part of the respondent authorities are clearly in violation of an office memorandum dated 4/2/2020. Next I first এখন অফিস মেমোরান্ডাম মই লিখাতে কলোৱে ইয়াৰ কম বেলেগ অজয় চৌধুৰী কোৱাই আছে অজয় চৌধুৰী কোৱা আছে The writ petition was preferred after a period of 2 years from the date of the suspension order dated 15/6/2023. Full stop. As on that, how many period of more than 26 years have elapsed from the date of the suspension order. Full stop. Oh. এইটো লিখিব in লৈ ল'ব দিব ইয়াৰ পৰা in the division bench in Subang Sang has observed as under paragraph 15. Paragraph 15. এটা পাৰ্টলৈ লিখিত আছে এইটো দি দিওঁ the in Koilan Dombivli Municipal Corporation. The respondent as delinquent came to be placed under suspension by an order dated 18/6/2018 after registration of a criminal case under sections 7, 8, 13 within bracket 1 within bracket small d along with section 13 in bracket 2 of the Prevention of Corruption Act 1988 on 14/6/2008 and his arrest. Post of. The respondent continued in custody till 17/6/2018. Post of. The authorities in the appellant municipal corporation decided to initiate and hold a disciplinary proceeding against the respondent, and the respondent was called upon to appear before the inquiry officer on an appointed day. Full stop. But the respondent chose not to participate in the disciplinary proceeding and instead, he preferred a writ petition before the jurisdictional high court on 21/2/2020. Full stop. Seeking setting aside of the suspension order as well as the resolutions taken by the Appellant Municipal Corporation for initiating and holding the disciplinary proceeding against him. Full stop. The jurisdictional high court by judgment dated 6/4/2021 allowed the writ petition. Full stop. Agreed thereby, the appellant municipal corporation preferred an appeal before the Honorable Supreme Court. Full stop. The Honorable Supreme Court considered the nature of challenges made by the respondent before the High Court. Full stop. It was contended on behalf of the Appellant Municipal Corporation that the High Court had grossly erred in holding that the respondent was an employee of the state government and therefore, it was only the state government who had powers to suspend him. Full stop. The Honorable Supreme Court, after considering the statutory provisions, relevant statutory provisions, came to a finding that the High Court had totally erred in setting aside the suspension and the disciplinary proceedings initiated against the respondent. Full stop. The suspension order was found to have been passed by the competent authority empowered under the what is the MMC Act?
Maharashtra Municipal Corporation Act,
Municipal Corporation Act,
1949.
1949. Full stop. Para. The Honorable Supreme Court in so and so, Kailan Gambi Valley, has further observed that the respondent was privacy. Respondent privacy was found involved in a serious misconduct Full stop. It was before the Honorable Supreme Court, comma, the learned counsel appearing for, learned senior counsel appearing for the respondent. Refer to the decision in Ajoy Kumar Chaudhary Supra. To urge on a matter of prolonged suspension of the respondent. Full stop. Full stop. The Honorable Supreme Court has not found applicability of the principles laid down in Ajoy Kumar Chaudhary to the delinquent despite prolonged suspension for the fact that despite his prolonged suspension for the fact that it was the respondent who had made who made the challenge to the suspension order and the disciplinary process on the ground of incompetency on the part of the authorities in the appellant municipal corporation. And therefore, comma, the respondent cannot be allowed, cannot be permitted to take benefit of his own wrong. Full stop. The respondent did not himself participate in the disciplinary proceedings so initiated. Full stop. The Honorable Supreme Court has therefore observed that the issue of prolonged suspension will be taken care of if a direction is made to complete the disciplinary proceeding within a stipulated period with continuation of the suspension period till then. Full stop. Having regard to the fact situation obtaining in the case of Kollan Dambi Valley Municipal Corporation, Supra. What are factual metrics obtaining in the case in hand, comma, this court is of the considered view that the decision in Kollan is the influence of not applicable in the case. So, in Pradeep Kolta, comma, the court has taken note of the conclusion of the inquiry and submission of the inquiry report and pendency of the decision from and pendency of the matter before the competent authority for taking appropriate decision. Most of the facts in those respects facts relevant in those respects have already been but those respects in the present case have already been eluded here in above. Have been adverted to. Have already been adverted to in here in above. In the affidavit in opposition. I'll change the paragraph. Yes. Randomly I have given paragraph. Later on I'll, in the affidavit in opposition, filed by the respondent number three. It has been admitted that due to certain official formalities, the so-cause notice could not be issued and served upon the petitioner as the delinquent within a period of within time. Full stop. It has also been admitted that the review of the suspension order dated 15/6/2023 could not be taken up in time. Full stop. Although should be interpretation of the day as well. Or rule 6 to the pairs. Propiko didn't know why didn't look at that. So only this order is to be if the petition. Okay, I set aside. It will order to set aside it. I do. If the petitioner has not been paid, has only been paid substance allowance at 50% till date and not at 75% for the period for which the petitioner is entitled during the period of suspension. Then the respondent authority shall initiate the process, initiate and complete the process for granting subsistence allowance to the petitioner at 75% within a period of 2 months from the date of receipt of a certificate. Reinstatement 15 days, right? Well, this will take some time, 2 months from the date of submission of the certified copy of this part. Other part I will adjust. Will not dictate again.
No issue, my lord. One small contention that I have contended, my lord, has been left out. In reply, I said that, my lord, the ingredients for keeping a suspension that your lordship has recorded in para 15 of the division bench judgment, tampering with the evidence, influencing the witnesses. Since they have admitted the departmental proceeding is over, inquiry report is submitted, those ingredients does not subsist.
So I have quoted that paragraph.
On that count also, there is no.
I have quoted that paragraph.
Yes, sir.
Paragraph 15 I have quoted.
It was my contention that no ingredients.
I have quoted paragraph 15.
Deeply operated. Deeply operated.